petition dismissed. However, liberty is granted to approach this court again by filing a petition.
Oblige, Lord.
May it please your lordship.
Hmm.
Your lordship, with due consent from other side, I beg to mention item number 24 of today's list, your lordship. Your lordship, counsel representing the case is not well, your lordship. So I pray that this matter may be taken up after vacation, your lordship.
Ms. P. Portakur, learned counsel for the respondent with consent the other side, as for listing the matter.
After vacation, your lordship.
Dr.
Obliged.
There.
Your lordship, I beg to mention item 27 of the daily list. This matter has already been compromised between the parties, but it could not be settled in the Lok Adalat, your lordship, because the IA was not numbered by then. The lordship will file a joint compromise petition soon, so the matter may come up after the vacations.
You are for the?
Appellant. I have taken consent from the claimant side, your lordship.
Okay. Miss
A. Biani.
learned counsel for the appellant with consent from the other side, as for listing the matter immediately after reopening of the petition. Fair allowed, recess allege the matter on
16th July
Your lordship, towards the end of July.
already.
on 38.
Oh.
30.
Much always.
One fresh motion matter, madam, I will take it day after tomorrow. CRP IO. Some urgent thing
Friday?
after.
Friday.
May it please your lordship. I beg to mention item number 3, your lordship. Learned counsel R. Sensor is out of station, your lordship. I am praying for an adjournment.
Item number 3.
Yes, your honor. It may be fixed on
Mr.
Friday, your honor, if it is possible.
Your good name?
R. Lahokot.
R?
R.A. Lahokot. R.A. Lahokot.
R.A. Lahore, learned counsel for the petitioner. Price for listing the matter on Friday.
Friday, your honor.
As the conducting counsel, Mr. R. Senso is out of station.
Yes, your honor.
On
Oblige,
20.
your honor.
May it, your lordship.
Yes.
Lordship, I beg to mention item number 43. In this case, we are supposed to file additional affidavit that we have filed today morning, lordship.
Item 43.
Lordship, record may be called for and it may be taken up at 2 p.m.
Okay.
Oblige.
May it please your lordship.
Mhm.
Praying for listing of a transfer petition, your lordship. The matter.
When?
Your lordship, the matter pertains to transfer of a case from Karimganj district to your lordship, Hailakandi. Sorry, your lordship, Kachar. District, your lordship.
When do you want?
Your lordship, 26th for motion, your lordship.
26th. Okay.
Deputy, your lordship.
May it please your lordship. Item number 7 to 12 is a part-heard matter, my lord, wherein, my lord, the government was directed to file an additional affidavit, my lord. I've received some instruction yesterday night, my lord. That is also not so conclusive about the queries that has been posed by this honorable court, my lord. So let this matter come up after vacation, my lord. In the meantime, my lord, I'll file my affidavit. I've informed the senior counsel appearing for the petitioner, my lord. Mr. K. Chaudhary, I've taken consent from him.
Mr. P. Kosik, learned counsel for the
Elementary.
respondent in elementary education
My
department.
lord.
With consent from the other side, price for listing the matter immediately after reopening of the vacation.
My lord.
Fair allowed. Up to item number 12.
7 to 12. 7 to 12.
Okay.
7 to 11, sorry. 7 to 11.
Yes.
Lordship,
Grateful.
I pray for listing of an item which is covered by the judgment passed by this honorable court. It may come in the 3rd week of July. Lord.
When?
3rd week of July.
3rd week of July. Okay.
Am I allowed to show?
Mr. Ziuddin, learned counsel for the appellant, submits that he has the instruction to withdraw this irregular first appeal. Fair is accordingly allowed. This RFA stands a disposal on withdrawal.
Right.
Oops.
It was earlier disposal. There was a earlier disposal.
Disposal.
Motion item 1.
May I please your lordship?
Hmm.
My lord, this transfer petition has been filed for transfer of some cases, my lord, which are pending in family court, Kamrup Metro, my lord. This is the matrimonial cases, my lord. 3 numbers of cases has been filed by the wife, my lord, and 1 numbers of case has been filed by the husband, my lord. My lord, the wife has filed 1 FC criminal case in Kamrup Metro Family Court, 1 DB, my lord, DB case, it is filed in Mongoldoy, my lord, Dorong, and another CR case, my lord, under section 498A, it is also filed in Dorong, Mongoldoy, my lord. And husband has filed 1 conjugal rights case, my lord, in Family Court, Kamrup Metro, my lord. Now, my humble submission is that, my lord, both the parties are living in the middle part of Guwahati and Mongoldoy, my lord. Husband is living in Dumni Shoki and wife lives in Mandakata, my lord. The distance are almost same, my lord. Now, my humble submission is that 2 cases are pending in Mongoldoy, which is filed by the wife. And 1 case is filed by the wife in Kamrup. And I have filed 1 case in Kamrup Family Court. So, the Family Court's 2 matter may be transferred to the Dorong Mongoldoy. And the distance is same, and it will be very beneficial for the witnesses also to come and adduce the evidences, my lord.
Let notice go at this instance. Art Mr.
KK Azad, my lord.
KK Azad, learned counsel for the petitioner, and Mr.
My lord, I would like to point out one thing, my lord. Page number 3, lordship, if you can turn up to page 3, my lord.
Yes.
Respondent 1 here, the copy which is served to us, the state of Assam to be represented by the public prosecutor represented by the before the Honorable Guwahati High Court. My lord, we are for the state and they have impleaded public prosecutor here. The copy which has been served us shows impleaded
That's
as,
made a correction subsequently. Only
but the corrected
was
copy has not been served to us. They haven't served us the corrected copy.
My lord, we will serve, my lord. Today itself.
Okay. And Mr. Your good name, please.
Jay Singh, my lord, government advocate.
Jay Singh, learned government advocate for the state respondent number 1. In this petition under section 24 of the Code of Civil Procedure, the petitioner has right for transferring FC certificate CRL case number 242 of 2022 under section 125 of the Code of Civil Procedure and FC civil case number 1068 of 2023 under section 281 of the Mohammedan law from the Court of Learned Principles, the Family Court at Guwahati, to any other court of competent jurisdiction within the district of Dorong. Dorong. Where is the petition and the documents enclosed therewith? Let notice be issued to the respondents, returnable in 4 weeks. State upon respondent number 2 be taken by registered post with AD and also by usual process within a week from today. No formal notice is required to be issued to the respondent number 1 since Mr. Singh entered appearance and received notice. However, extra requisite copy of the petition be furnished to him during the course of the day. List the matter after 4 weeks. Interim pair of the petitioner will be considered on appearance of the other side. List after 4 weeks.
Item number 2.
Publish.
May I please your lordship? Lordship, the matter may be taken up after some time, lordship.
Whether you have filed an additional affidavit.
Lordship, my senior is in another court. He will come. It can be taken after some time, lordship.
No, I am asking you whether you have filed the bring on record the petition number 1342 of 2022.
No, lordship.
No. Yeah.
Might be the lordship. I'm sorry, lordship. In this matter, lordship, on last occasion, I have taken time on the ground that I'm going to submit the certified copy of the petition along with the sale deed,
You
Lordship.
received it?
No, Lordship. They informed me that, Lordship, the sale deed was exhibited in the title suit, Lordship. The second suit which was filed. So your Lordship was issuing notice on that day. Lordship may issue notice without any stay prior.
Impaired will be considered later on.
Lordship. Otherwise, Lordship, the order itself says page 86, your Lordship
That's all
will
right,
find.
but there is an order for correction of the petition. Or means our Supreme Learned Council for the. But unless there is specific direction of this court.
Lordship, I prayed for, your Lordship was about to issue notice. Then I prayed for stay. Then your Lordship said, you have not submitted the sale deeds before the learned trial court. How the trial court order is wrong, Lordship. Then I have submitted that it is information that sale deeds were submitted.
And that's all right, but if we issue notice today
Lordship.
without production of the document, then
No, sale deeds I have enclosed, Lordship. In my
no, that
stipulation-
petition. Petition number 1342 of 2022.
Lordship.
That
Petition-
produce it next week. We will.
Lordship,
submit that.
they have informed that they have not enclosed the certified copy of the sale deeds along with the petition, but the subsequent title suit which was filed by the petitioners, the third party has already filed a title suit, Lordship. In that title suit, they have original sale deeds already submitted, Lordship.
That's all right. You produce the petition number 1342 of 2020.
Petition I have enclosed, Lordship. The
Right.
petition I have enclosed here, Lordship. Section 47 petition, page, annexure 5, page 49, Lordship.
No, not 47. That under section 21,
That
rule
is the
97.
That is the petition, Lordship, annexure 5, page 49. Your Lordship kindly see. An application under section 47 and under order 21, rule 97, 98 and 101. This is the impugned petition, Lordship. Against this petition, the impugned order was passed, Lordship. There is a decision of Supreme Court in Samir Singh, Lordship. It says executing court has to decide all dispute, Lordship. Even the
That's
application.
all right. There is no dispute about the proposition of law.
My prayer is that, Lordship, the executing court, page 49, Lordship, annexure 5.
Page
9. Petition number 1342/22. This petition was rejected by the learned executing court. And the case of the
This petition was not accompanied by any sale deed.
No, Lordship.
As directed by the learned, as observed by the trial court, executing court.
Yes, Lordship.
So you produce the sale deed then?
Sale deed I have enclosed, Lordship.
Where?
Here, Lordship, annexure 3, page 36. By which our rights we obtained, Lordship, from the predecessor of the plaintiffs of that title suit, Lordship, which was put into execution, Lordship. Our case is that we are the parties who are occupying the lands we have purchased from the predecessor of the plaintiffs, and thereafter we are occupying the lands, and now they, without impleading us, filed a title suit and obtained a decree, and they are going to execute that decree, Lordship. And there are several judgments of Supreme Court who says, Lordship, even if third party filed any application, that to be executed by the executing court. And here in my petition also, I have mentioned about the registered sale deeds, Lordship, page 49. There is a mention of the registered sale deed, how we have purchased. Paragraph 2, Lordship, that the predecessor in interest of the decree holder, Moniruddin Sarkar, has executed a sale deed by so-and-so in favor of Raso Mondal in respect of a plot of land 3 bigha 2 katha 9 lesa, that thereafter the decretal suit land has been transferred by said Raso Mondal, executed registered deed so-and-so in favor of Abu Bakr Siddiq, that is the father of the third party petitioner. So we obtained, Lordship, ownership through Abu Bakr, who purchased from Raso Mondal, and Raso Mondal purchased from Moniruddin. Moniruddin is the predecessor of the plaintiffs of this title suit, which is being executed by the executing court, lordship. So prima facie, we have proved that we have right, lordship. Executing court ought to have lordship fix it for evidence. As because there is a bar of filing second suit, lordship, the executing court is the competent authority to decide the right title interest of the third parties, lordship. And I have enclosed both the sale deeds. Page 36 is the sale deed, lordship. Moniruddin Sarkar, he is the predecessor of the present decree holders, lordship. Sold the land in favor of Rasamandal and
No, the cell deed you have annexed is cell deed number 387 of 1963.
yes,
But in
lordship.
your petition, you have referred to cell deed number 3423 of 1968. Where is that cell deed?
Page 49, lordship, executed a sale deed by 387. Page 49, lordship. On 25/1/1965, this is exhibit annexure 3, lordship, 387 of 1963.
No, no, the original cell deed number 3423 of 1968. That has been mentioned in paragraph number 4 of that petition.
Three, four, lordship, that is our purchase deed from Rasamandal. That also I have enclosed, lordship,
Where?
in page number 42. Predecessor of the plaintiff sold it to Rasamandal and we have purchased from Rasamandal, lordship. This Rasamandal, son of late Jamal Mandal, lordship. And page 36 also same person, Rasamandal, son of late Jamal Mandal. Moniruddin Sarkar is the predecessor of the decree holders, lordship. So we have prima facie proved that we have some right over the decretal land. And they, lordship, did not made party these persons in their title suit. They made some other persons as defendants and contested the case, and lordship expertise judgment was taken.
Then why this order was passed on that day?
Lordship, on that day, your lordship was about to issue notice only. No stay order was about to be passed, lordship. So I prayed that it is information that along with the petition, we have filed the sale deeds, lordship. Then your lordship permitted me to bring the certified copy of the petition along with the sale deeds. When I inquired, they
So
informed
these
that
are not certified copy.
these are certified copy, but lordship, these are already with the petitioners, lordship. Along with the petition, they did not enclose, lordship. So my case is that, lordship, the executing court, while given the finding that the third party did not produce any sale deed, the executing court ought to have fixed another date for producing the evidence by the third party, lordship.
Well, let notice go at this. Hardness are superior, learned counsel for the petitioner. In this petition under Article 227 of the Constitution, yeah, the petitioner has challenged order. Read it section 151 of the Code of Civil Procedure. Challenge the order dated 13/8/2022, passed in the case number 22 of 2022, arising out of title like petition case number 10 of 2021 by the learned civil judge North Salmara of Vibrary. This to be noted here that by impugn order dated so the learned civil judge junior division North Salmara is dismissed the petition bearing number 1342 of 2022 filed by the petitioner under section 47. Read with order 21, rule 97, 98, and 101. Read with section 151 of the Code of Civil Procedure. Peruse the petition and the documents enclosed therewith, and also peruse the order dated 13/8/2024. Impugn order dated 13/8/2024. Issue notice returnable in 4 weeks. Step be taken by registered post with KD and also by usual process within a week from today. List after 4 weeks. Interim pair will be considered on appearance of the other side.
Lordship, can it be a fixed date after July, Lordship? July last part, any fixed date, Lordship?
28 July.
Lordship, I'm deeply afraid.
Item 4.
May I please, your lordship? My lord, issued for declaration as well as, my lord, recovery of position was filed by me, by the, the plaintiff petitioner, my lord, before your lordship, and wherein the evidences and the pleadings were exchanged. Thereafter, my lord, evidence of the plaintiff was led and cross-examination was done. In the meanwhile, my lord, the defendant filed an application under section 45, my lord, and that was rejected by order dated 24/8/2023. That is, my lord, at page number 51. Page number 51. Thereafter, my lord, the learned trial court directed them to file their evidence, and in the verge of the filing of the evidence, my lord, another application was filed when the Act of 2023 came, my lord, under section 39 of the BX Act. That is allowed, my lord, without formality, by the same officer, my lord, paid same judge, by the same presiding officer, my lord. I would like to take your lordship to page number 51 first.
No, is there any bar considering the pair in second time?
My lord, there is bar in the sense that they only dispute that exhibit number A to T, which they have filed, we have denied some of the signatures. So, my lord, unless the cross-examination comes, there is no question of denial. At the time of filing our evidence, my lord, we have said that these are the money which we have received and these are the documents which are forged. They have filed those documents also and saying that these are the documents by which the money was taken, but the signature is not their own. So in between, my lord, if I can take your lordship to page number 51, only one line, my lord. Page number 51. My lord, the last paragraph. Upon consideration of the facts of the case in its entirety, I am of the considered opinion that since the matter concerned is only regarding denial of signatures in the exhibited money receipts by the plaintiff number 1 and 2, the admissibility of which shall be determined by this court only at the time of the final adjudication of the matter, the exercise calling for expert opinion as prayed for by the petitioner defendant is not necessary at this stage. However, the same shall be considered after closure of the defendant's evidence for proper adjudication of the dispute between the. So, my lord, by this way, the time was mentioned that the defendant's evidence must get closed only thereafter that application.
No, by this order, the learned court has not
the impugn
at all
order is
dismissed the
page 62.
petition. It is stated that shall be considered after closure of the defendant's evidence.
Yes. So let the defendant's evidence, my lord, according to my respectful submission before your lordship, let the defendant's evidence be complete. Only thereafter this exercise can be made. There is no harm upon. But in between, if it is done, my lord, it will certainly prejudice me. It will be half done way.
How?
My lord, let him file all the evidences which is required to be filed by the defendant before the learned trial court. And let me also cross-examine the defendant, my lord.
No, without cross-examination, how prejudice will be caused for you?
Without no, my lord, at the very outset, I am the landlord and she is my tenant. And the suit is filed for the eviction, my lord. On the ground of bona fide requirement as well as, my lord, defaulter. Defaulter. They say that we have paid rupees 13 lakhs to me, but they have not paid rupees 13 lakhs to me. They have got certain documents from A to T, which is not having my signature, my lord. I mean the plaintiff number 1 and 2. So that's why at the earlier stage, my lord, the learned trial court came to the finding that let the evidence be exhausted. Only thereafter, even if it is considered, I don't have anything to say, my lord. And without reviewing that earlier order, my lord, this order is passed by the same presiding officer.
Maybe.
there
Earlier,
was-
earlier that prayer was not rejected.
No, earlier, my lord, the prayer was considered subject to the condition that the defendants are required to file the written statement. I will say the evidence. It is not exhausted, my lord. From 23/9/2023 till 24/9/2024, my lord, that has not been done. So let them exhaust that, let them file their, evidence, my lord, so that they cannot go away from that, my lord. If the evidences are filed before the learned trial court, my lord, of the defendants, and if thereafter the
Now, what it says the case is pending.
filing of the, evidence in chief by the
DW.
DWs, my lord. Because if, my lord, the DW is there already on record, I have got nothing to say. Because their evidence is very much before that, I would get a chance to cross-examine them, my lord.
Heard Mr. Sutter, learned counsel for the petitioner. In this petition under Article 227 of the Constitution of India, the petitioner has challenged the correctness or otherwise of the order dated 17/2/2025 passed by the learned civil judge General Division Bongaigaon in Mijay case number 89 of 2024, arising out of title suit number 08 of 2018. It's to be noted here that by impugned order dated so the learned trial court has allowed the petition filed by the respondent herein under section 39 of the BNS. Read with section 151 of the Code of Civil Procedure for sending the signatures of the plaintiff, the signature of the petitioner herein, number 1 and 2, and the signature of the predecessor in interest of the petitioner number 3, 1 and 3(2) as contained in Exhibit 1 and Exhibit A3, right, A-3, along with their respective specimen signatures for expert opinion at FSL Guwahati during the order dated 24/8/2023. Mr. Sutter, learned counsel for the petitioner, submits that the petitioner herein institute a title suit number 08 of 2018 for eviction.
Yes, my lord.
For
Yes,
eviction
8
of
of
the
2008.
respondents herein from the tenanted premises. Tenanted premises. And in the said title suit, the respondent herein entered evidence and filed a written statement, right?
Written statement come counterclaim, my lord.
Written statement come counterclaim.
Yes, my lord.
Counterclaim. Counterclaim. And during the pendency of the aforementioned proceeding, on 24/8/2023, the respondent herein had preferred a petition
Similar section was there, my lord, section 45 at that stage.
789 is the petition number.
Yes, my lord.
Petition number 789 of 2023, dated 21/3/2023, under section 45 of the Evidence Act, Indian Evidence Act. Read with section 151 CPC for passing necessary order to obtain expert opinion regarding the disputed signature of the plaintiff number 1 and 2, which has been exhibited as exhibit number A, D, and exhibit 1. Thereafter, hearing learned counsel for both the parties, the learned trial court has observed that the petition will be considered after closure of the defendant's evidence for proper adjudication of the dispute between the parties. So Sutter further submits that thereafter, on 18/2/2025, the defendant, the respondents herein file another application, another petition being petition number 1680 of 2024 under section 39 of the BNS with section 51 of the CPC for passing necessary order to send the signature of the petitioners herein number 1 and 2, and the signature of the predecessor in interest of the respondent number 3, certificate Roman 1 and Roman 2, containing in exhibit 1 and exhibit A, D, along with their respective specimen signatures for expert opinion at FSL Guwahati. And thereafter, hearing learned counsel for both the parties, the learned trial court was pleased to allow this petition, ignoring the order dated 24/8/2023. So Sutter further submits that while there was specific direction that the petition for obtaining expert opinion will be considered only after closure of the evidence of the defendants, respondents hearing, but without ignoring, without the evidence of the defendant being completed, the learned trial court has subsequently allowed the petition number 1680 of 2024 for obtaining the expert opinion in respect of exhibit 1 and exhibit A3, and unless and until the evidence of the respondents herein are completed before the learned trial court, the petitioner herein will be prejudiced, and therefore Mr. Sutter submits that the impugned order fails to withstand the legal scrutiny, and therefore it is completed. Having heard the submission of Mr. Sutter, learned counsel for both the counsel for the petitioner, I have carefully gone through the order dated 24/8/2023, and also the order dated 18/2/2020, impugned order dated 18/2/2020.
My lord, 18 is deleted, it is made 17.
17.
Yes, my lord.
17. It appears that in the order dated 24/8/2023, the learned trial court has observed that the petition will be considered after closure of the evidence of the respondents hearing. But subsequently, the petition in another petition filed by the respondents hearing on 17/2/2025, the learned trial court has allowed the pair without examination of the witnesses of the respondents hearing. Thus, taking note of the submission of Mr. Sutter, learned counsel for the petitioner, and also considering the facts and circumstances, it is provided that the direction given in the order dated 17/2/2025 shall not be given effect to till completion of the examination of the witnesses of the respondents
My lord.
before the learned tribunal.
No.
In terms of above, this petition stands disposed of, but this motion is accepted.
Obliged, my lord. Obliged.
Item number 5,
It's been a tough case. Yeah, please, my lordship. Petitions have filed one title suit that is pending before the Court of Learned Civil Judge Junior number 4. That suit is presently at a stage of cross-examination of the PWG. The defendant number 1 of this suit had also filed one probate application before that is pending before the Court of the Learned District Judge. And in that suit, the present defendant number 6 of this suit was the OP number 11 in the probate suit. In course of cross-examination of the probate petitioner, kindly see page number 71, Your Honor. Page number 70. Page 70 and Exhibit 4. In course of cross-examination of the probate petitioner, Munindra Das, who is the defendant number 1 in this suit, in my suit, he stated that Niru Das, who was the OP number 11 in that probate suit, and defendant number 6 in this suit, has already expired. That is, kindly see next page, page 71. Second line from the bottom. I know that Niru Das, that is OP number 11, had already expired about 1 year back. But legally, this information was not given by the Munindra Das, who is defendant number 1 in my suit, before the learned trial, Court of Learned Civil Justice Junior number 4. Thereafter, his statement is that I know that Niru Das, OP number 11, had already expired about 1 year back. Niru Das had left behind her 2 daughters as her legal heirs. I have not submitted any application for substitution of legal heirs of Niru Das, OP number 11. I cannot say case against OP number 11 is abated. Anyway, in spite of admission in his cross-examination in PTS, he did not file the names of the legal heirs of also in the.
No, Mr. Morzo, you tell me why you have not enclosed the death certificate with the.
My lord, I am not. See, the person who expired is not my family member. So I cannot obtain the death certificate, my lord. And as even the counsel for the probate petitioner, who was the defendant number 1 in my suit, he was also obliged, my lord, to file the give the information about the death of the Niru Das, who is the defendant number 6 in my suit. Anyway, when I came to know about the death from the cross of this probate application, I filed one petition for substitution. That petition is, my lord, at page number 73-74. But that petition was rejected, stating that this is not in proper format. But what is the? But why did you in not proper format, but not this disclosed by the London Munsif in the order sheet? But on the body of that petition, that is page number 73 and Exhibit 5, one noting is there that no affidavit. Although petition was a verified petition, subsequent petition was, but anyway, this petition was rejected, saying that liberty was given to me while a further petition in proper format. And one of the reasons for rejection was that also that it is not a copy of the death certificate is not enclosed. So, my lord, I tried my level best to obtain the photocopies, but I could not get anyway. Thereafter, on 24/7, Your Honor, my lord, I filed another petition for substitution. That is at page number 76 and Exhibit 7. And this petition was rejected by the learned civil judge Junior number 4, holding that it is by that time the suit is already abated against defendant number 6 because it is not filed within time. My lord, my earlier petition was within time. That was filed on 29/5/23. Death of information came to me. Information about the death came to me on 29/3/23 in course of cross-examination of the PW Munindra Das. Thereafter, that petition was filed for substitution on 29/5. within 90 days, my lord. And that was rejected. For the two reasons: number one, that not annexed with the death certificate, and second, not in proper format. But in proper format, actually, I could not gather, but only from the noting on the body, no affidavit, I could believe that it is not for that reason. But as regard death certificate, I tried my level to obtain, but I could not get that. So I filed another petition.
No, that's all right. You have filed a petition subsequently.
Yes,
Uh,
on
and,
24/7.
whether you have filed any application for condonation of that
My
event?
lord, for setting as a abatement or contrary delay, I did not file. I was of the one of my belief that this my earlier petition was within time, so this is a continuous of that petition.
Okay.
Thereafter, my lord, I
Motion
filed.
Learned Counsel for the petition. Petition under Article 227 of the Constitution of India. The petitioner has selected the correctness or otherwise of the order dated 12/6/2024 passed by the Learned Civil Judge United number 4 Carter M. Guwahati entitled suit number 26 of 2021. Reject and it is to be noted here that by the impugn order dated since the Learned Civil Judge Junior Division number 4 herein after trial court rejected the petition number 1252 of 2023 filed by the petitioner on 24/7/2023 under order 42-4 of the Code of Criminal Procedure for substitution of legal heirs of Nehru Das. The defendant number 6 entitled to number 26 of 2021. Mr. Morzal, Learned Counsel for the petitioner submits that the petitioner has instituted on title suit being ES number 26 of 2021. Wherein the respondent herein submitted entered appearance and submitted their written statement in the said title suit. Mr. Murzo further submits that during the pendency of the said title suit, the defendant number 1 Srimati Nehru does subordinate, but the said information was not received by the trial court from the Learned Counsel to the defendant number 6. And and being aware of the said fact, the petitioner herein filed one substitution petition being petition number 732 of 2023. But the Learned Trial Court has dismissed the said petition by holding that it is not in proper format and not accompanied by the death certificate of the deceased defendant number 6. And subsequently, the petitioner has filed another petition being petition number 1252 of 2023, but the said petition also came to be dismissed on the ground that the petition was filed after elapse of the limitation period, and in the meantime the suit stands abated against the deceased defendant number 6. Defendant number 6, Srimati Nehru Das. So Morzo further submits that the defendant number 6 was not the family member of the petitioner and the petitioner was not aware of about her death, and the same was not informed to the court also by the Learned Counsel for the defendant number 6. Defendant number 6. And that the petitioner has filed the petition within time. First petition numbers 732 of 2023 within time, and the same was dismissed by the learned trial court on the ground of not filing the same in proper format and the death certificate being not enclosed with the same. So why the second petition could not be filed in time?
My lord, meanwhile, I was searching for the death certificate and these things, but I would try my level to obtain the photocopies from there, but I could not get.
Further, Mr. Morjo submits that after the first petition, being petition number 732 of 2023, came to be dismissed, the petitioner tried to collect the death certificate of the deceased defendant number 6, but he could not succeed.
Well, this is also not objected by the other side while in course of hearing.
Have you mentioned the reason for delay in your second petition?
My lord,
That page number?
second petition at page number 76, 78. About death certificate, I have not mentioned anything in that.
No, there you have mentioned that you have filed a petition within the prescribed time limit.
Actually, my lord, earlier petition, in fact, earlier petition was within time limit, not this. This is by some typing mistake, my lord. Earlier petition was within time. Seven 32 is page 73. That was filed on 4th May 23, earlier petition. Even
Have
my
you
lord,
heard
if
the
liberty is
submission of Mr. Morjo, learned counsel for both the parties? I have carefully gone through the petition and the documents plus on the record and also verifying order dated 12/6/2024. Taking note of the submission of Mr. Morjo, learned counsel for both the counsel for the petitioner and also considering the facts and circumstances of the record. This court is inclined to dispose of this petition by directing the petitioner to file a fresh petition before the learned trial court. Under Order 22, Rule 4 CPC, for substitution of legal heirs of This is respondent number 6, explaining the reason for which he could not file the petition within the stipulated period. Then, on such petition being filed by the petitioner herein, the learned trial court shall consider the same in accordance with law. In terms of error, the CRP is disposed, and this motion is itself.
My lord, fresh petition. Fresh
Yes,
petition. I will file
Within-
along with
within a
delay
period of-
other thing. I will
within a
file.
period of 1 week from today.
My lord,
Within a period of 1 week from today.
obligement.
Item number 6.
Order the line.
Let me just illustrate.
Order stands interfered with to the extent indicated.
Here in this case, we have impugned two orders, my lord. At or page 118 is the order dated 7/3 and another order is at page 123 is the 13/5. What has happened, your lordship, in this case? Firstly, I am the defendant in the suit, and my amendment for written statement was allowed by order dated 31 on being satisfied at page 57. It was allowed with a rider with as a condition precedent by imposing cost of rupees
You
3,000.
see, you have been allowed to amend the
Yes, my lord.
written statement.
And on the date fixed on 7/3, my lord will see at page 111.
What ground you have assigned
That
for
on that
failing
day,
to
the
file
defendant
the
fell ill, my lord.
amended written statement within the stipulated period?
Yes, my definitely. On the next date fixed on 7/3, the defendant fell ill. He could not come to the court for deposit of the cost as well as for signing the
Why?
amendment. He fell ill, my lord. That is the
Why?
petition I have filed. He fell ill.
Pardon?
He was not keeping well on that day, on 7/3. That was on the very first day. Adjournment petition was filed, my lord, at page 116. Kindly see the petition at page 116. May I read, my lord? Annexure 6, page 116. Today is the date fixed in the above noted case for payment of cost. For payment of cost. In
Whether this petition was supported by any medical document that you were suffering
that I am
from?
not aware, my lord.
You were
That
suffering
was
from
rejected,
illness
but
and
on the ground, kindly see the ground for rejection at page 118, the first
No, no.
impugn order.
Let us first consider your ground.
Yes,
You have assigned in your petition. What ground you have assigned?
may I read the whole petition, my lord? That today is the date fixed in the above noted case for payment of cost of rupees so and so in connection with miss case number so and so. But the defendant could not come to the court today due to his illness caused for fasting during the Holy Ramjan. And that day, during those days, my lord, he was on
Whether that
fasting.
is the just ground.
That was only the ground we have taken. That was the in fact.
And you have also taken
And
the
this is
ground
the
of
only,
illness.
my lord, this is the
Where is the
only-
medical document?
my lord, this is the only first date fixed. We have sought the adjournment and kindly see the reasoning at page 118. It is not that the court does not have the power to extend the time.
Maybe.
No, no, my lord. But here the region has been assigned that as per order 6 rule 18, it has been embargoed. That is the only reason assigned, my lord. Kindly see, in view of order 6 rule 18 CPC, defendant side is embargoed from appending their written statement unless the court has the ample power, my lord. And my lord, this is the suit for declaration of right title.
But
My lord, kindly see. And thereafter, my lord, the matter was fixed for DW. In the by overlooking the fact that a FSL report was called for at the behest of the defendant's application, which was allowed in the year 2015 itself. From 2015 till date, my lord, FSL report has not come. And without that FSL report, the defendant could not have adduced their evidence, my lord.
what step you have taken?
Yes, my lord, there is the steps we have taken from time to time. It has never been stated that we have failed to take the steps. Steps has been taken, but till that report has not come. Kindly see my petition.
You show me the orders, what step you have taken?
It reflects, my lord.
Where?
Kindly see page 96. Issue a reminder to the officer in charge. Page 96, my lord, third paragraph from the bottom. It is there, my lord. Even at page 98, 96, third paragraph.
Page 99, your lordship may kindly look at page 99. Fixed so and so for evidence of DW and FSL report. And from 2011-23 onwards till 18-11-24, the Honorable Court was on leave. Page 106, your lordship will kindly see page 106 to 107. And accordingly, we made the petition, my lord, page 121. That today is the date fixed in the above noted case for evidence of the defendant side. But since the report of regarding the AFSL examination of the purported deeds of the defendant side has not been received from the AFSL, yet it is not possible to submit evidence. Only on this genuine ground, my lord, it is the order was passed by the Honorable Court for that it is required for proper adjudication of the suit. The plaintiff is basing their claim upon a one sale deed, which according to the plea of the defendant is a forged document. And accordingly, the Honorable Court was of the opinion that is for the just decision of the suit, that FSL report is required. Until unless that report is received, the defendants are prejudiced to file their evidence, my lord. Only 2 adjournment petitions has been made. Now my right of adducing evidence has also been closed. The matter is fixed for argument on 4-7, my lord.
No, it appears that rightly the trial court has did it.
No, my lord, I am not on that. So,
On
court,
what then?
my lord, it is not that the court has not power, and we have been precluded. We have been precluded from a sufficient cause, my lord. He has stated. He has stated in first petition in page 116 that on that day, due to fasting, he was not keeping well, so he could not come to the court. That was the only first occasion, my lord.
No,
Thereafter,
your main ground is that he was suffering from illness.
Illness on on account of fasting, my lord. On account of fasting.
I am asking you, where is the medical document?
For one day, that is not keeping well, so
Not keeping well.
because of the
So
fasting,
court
he was
has the
not keeping.
power and the court has to accept each and every of your
I am not on
unlawful
that.
and illegal demand.
I am not saying that it is.
Then you are trying to demonstrate the same before
Only
this
the first date was adjournment was sought, my lord, on the very date
So,
fixed.
you
It is
do
not
one
that we
thing.
want to delay the case.
You
Thereafter, my lord, FSL report did not receive. So we were precluded from our filing our evidence, my lord. That would have prejudiced our cause without exhibiting those documents in evidence.
first they bring on record what step you have taken in respect of the FSL report.
I will file my that. I will take the instruction from the engaged counsel. I will file that steps. Because otherwise from the.
G. Jalan, learned counsel for the petitioner. After hearing Mr. Jalan, learned counsel for the petitioner, it is provided that he shall bring on record the steps he had taken before the learned trial court in respect of the FSL report. List after 1 week.
Published. Yeah, any date may be fixed, my lord, because next date is fixed on 4/7. Any date, my lord, before vacation.
No.
Published.
Yeah, please, my lord. My lord, the impugn order is at page 42, my lord. It starts page 42.
You are the petitioner here.
Here, in this case, I am the petitioner, my lord. And in the suit, I am the defendant. My lord, my prayer for calling of the misrent cases as well as one GR case was rejected by the impugn order, my lord. My lord, it starts from page 42. And my lord, the finding of the court is at page 43, my lord.
Why the petition was dismissed?
My lord, mainly on two grounds, my lord, the lordship may come to,
Where is that appeal order?
my lord, it starts from page 42
40.
and relevant will be, my lord, 43 from last paragraph, my lord. Lordship may come to page 43, my lord. Mainly on two grounds that I have failed to take steps.
Yes, what wrong with the order?
My lord, first thing is, my lord, this with regard to GR case number 294, 2005, my lord. The court says that,
So you have not taken step.
yes, my lord, what happened, my lord? We have taken steps earlier on, only on one occasion, my lord. That is on 4/11/2024. The counsel of the petitioner failed to take the steps, my lord. I have annexed the orders, my lord. Lordship may come to page 33, my lord.
Page number?
Page number 33, my lord. Lord, order dated 4/6/2024. Parties are represented by petition number so and so plaintiff side sought adjournment for cross-examination on the ground that due to unavoidable work, PW1 has gone out of station. Letter dated 4/6/2024 is received from dealing assistant record room office of CGM Tinsukia, praying for some time to search case record of GR case number so and so. Reference to Tinsukia PS case number so and so. Heard prayer is allowed. Fix 11/7/24 for record. Then my lord 11/7/24. Parties are represented. Record is not yet received. Fix 16/24 for record. Then my lord page 34. Order dated 16/24. Both sides are represented. Call for the record of so and so is not yet received. Dependent side is directed to take a step to call for the record of GR case number so and so. Then my lord 26/9/24 almost same order. Then my lord 4/11/24. Parties are represented. No step is taken by the defendant side for record of GR case number so and so despite opportunities given to the defendant side. Hence this court deem it fit to proceed with the instant case fix so and so for further cross-examination of PW1.
Yes, Mr.
And my lord,
Yes. May I please allow? So this is a purely suit of the landlord-tenant suit. In a landlord-tenant suit, only issue has to be decided whether the defendant are defaulter or not. In the instant they have filed a petition calling for two records. The one is the FIR they have filed against us, and that record is not necessary. The learned court below has give the liberty to file the certified copy of that record. And so far the RAN cases is concerned, during the hearing, counsel for the plaintiff has admitted that they are depositing the RAN, so not disputed, and that they have the salons, the RAN deposit salons, they can very well exhibit those documents. So for that purpose, since 2022, suit is pending for cross-examination of the PW1. So in such circumstances, Lordship, in recently, this honorable could pass an order in similar fact situation, Lordship, wherein after the cross-examination of the PW1 in a RAN control suit, the defendant side has filed a petition for calling a record of a misprobate case, which has been disposed of. Thereafter, they lingering the matter. Ultimately, court is also adjourning the matter, giving time after time. In that situation, the entire proceeding has been challenged by in the judgment, Lordship. From paragraph 11, Lordship, very recent, Lordship. Since it's a landlord-tenant suit, only issue has to be whether defaulter or not. We are not disputing that they are not depositing the RAN in the court. So far, depositing the RAN, it is admitted position, and they have the salon. They can very well exhibit this. And regarding the GR case, they can very well submit, exhibit the certificate copy, and liberty is also given. Yes, Lordship. The order is balance order, Lordship. Everything has been considered. And they admittedly, they have not taken several since 2022. This suit is pending at the same stage of further cross-examination of the PW1. And we are admitting that they are depositing the rent in the court. Since the plaintiff himself admitted the depositor of rent, so what required to be proved? It's admitted. And they have the salons because every rent deposit they got a salon. So they have that salon. And regarding GR case, they can first exhibit the FIR. And that liberty is given in the MP order.
With regard. My lord, with regard to relevancy of GR case, my lord, with regard to reason for calling that GR case, my lord, I have stated in my.
Why the GR case is required in case of this
Yes,
rent?
yes, my lord, I have stated in my written statement as well as my petition. My lord, if lordship may come to page 27, my lord.
No, how that record is relevant?
Yes, my lord, I have stated the reason. What happened, my lord? The petitioner was regularly paying the rent till October, October, as per the plaintiff, October 2019, my lord. What happened? There was some quarrel took place, and thereafter the petitioner has paid the rent to him, but rent receipts were not issued to the petitioner, my lord. Then, my lord, thereafter some months, this instant suit was filed. To show that, my lord, this suit is the, my lord, outcome of that quarrel which took place for which the GR case was lodged. And, my lord, these all things were stated in the written statement. And, my lord, there also the prayer was there to crave leave of to call for the record of that GR case. And that prayer, and subsequently thereafter, my lord, a petition was filed for calling the GR case records that was allowed by the court, my lord. Only since on one occasion, the counsel of the petitioner has failed to take steps, my lord.
That's all right. You can obtain certified copy of that GR record and produce.
Yes, Lordship.
my lord-
Only that FIR has to be proved, nothing more, nothing less.
My
The
lord,
criminal court will see what is the outcome of the GR cases.
my lord, with
Like
regard,
a landlord tenant suit. That has no relevancy at all, Lordship.
my lord, my submission is that, my lord, once the court has allowed my prayer to call for the GR case record and only rejected on the ground that I have failed to take steps.
No,
My lord,
court has allowed, court has given sufficient time to you also, but you failed to take steps.
My lord, I have taken the steps. It is not that, my lord, I have not taken it. So only on one occasion, my lord, that is 4/11/24, that my counsel has failed to took the steps, my lord. Then, my lord, one petition is also filed for recall of that order. And, my lord, with regard to certified copy, my lord, lordship knows that, my lord, every document has to be produced by the primary evidence, my lord. And if the secondary certified copy is just since a secondary evidence, my lord, for that, my lord, the criteria provided under section 64 of the Evidence Act has to be fulfilled, my lord. And, my lord, no prejudice will be caused to the other side because I am calling for the record. And, my lord, apart from the GR case, also the rent cases are also called for, my lord. And, my lord, even the court, my lord, the petition file is not at all considered because the court is confused, my lord. Earlier also there was one petition with regard to calling for the rent cases, my lord. That was allowed and that records were called, my lord. My lord, that two different petitions, my lord, for calling of the different records. And, my lord, lordship in a similar fact, my lord, with regard to, my lord, misrent cases, my lord, lordship has allowed to calling for the records, my lord. That I have to do. My lord, in this case, my lord, the prayer was only with regard to calling the misrent cases, my lord. In this case, which I have given, my lord, it was decided by your lordship. And, my lord, in this case, the prayer was only to call for the misrent cases that was rejected by the trial court. And lordship has allowed the prayer, my lord. If lordship may come to paragraph 6, 7, 8, and 9, my lord.
That's all right, but you have been given a sufficient opportunity.
My lord, with regard to misrent cases, my lord, no opportunity was given, my lord. And my lord, my prayer was even not, my submission is that not at all considered, my lord. Because there are two different petitions.
No, the trial court has observed that the other side has not disputed regarding.
My lord, there is no
positive or-
admission, my lord. In fact, there is no admission on their part, my lord.
It
In-
is recorded in the order itself, Lordship.
My lord,
I have specifically instructed.
My
The plaintiff has given no objection.
my lord, against the petition, they have not filed any objection or anything. So there is no admission on their part. Only, my lord, verbal saying will not do, my lord. This is a civil suit, my lord.
My statement may be recorded, Lordship.
My lord, in civil suit, lordship knows that, my lord, verbal statement has no value. Still, it is on the record, my lord, by way of a pleading or like that, my lord. Because in the pleading, they are denied everything, my lord. In the plaint, they are not saying about anything, my lord. And my lord, even if the records are called, what prejudice will be caused to them, my lord? Because they are saying that they are also praying for area rent or all this, my lord.
Lordship, original petition was filed in the year 2022. That was allowed on 3/6/2022. Since then, the suit is pending at the same stage. Further cross-examination of the PW1. Already 3 years elapsed, Lordship. And the last part of this order, Lordship, it amounts to allowing them to adduce secondary evidence, Lordship. Liberty has been given. For the rent cases, which we are not disposing at all, because dispute is in between the prior to depositing the rent until November 2019.
Okay, we'll pass the order.
And my lord, in the plaint, just only one submission, my lord, in the plaint, they have also prayed, in the prayer portion, my lord, they also prayed that a decree for recovery of compensation rupees 500 per day from 5th July 2020 till the date of eviction of the defendant from the suit premises and handing over the vacant and cast possession of the suit premises to the plaintiffs. That is the prayer in the plaint. One of the prayers, my lord. So that's why these rent cases are also required.
Okay.
Oblige.
Number 45.
May please, Your Lordship. Impugn order is, my lord, the start from page 46. My cross-examination has been closed, my lord, and fixed for DW. On the ground that, Lordship, I have taken 3 more adjournments. And simple, Your Lord. Page 46.
Order dated 21/5/2025.
Yes, Your Lordship. Today is fixed for cross-examination, Commissioner. Actually fixed for Commissioner report, Lordship. But Lordship, as PW1 is present,
Where it is mentioned that it was fixed for commissioner's report.
that the earlier order, Lordship, I could not annex, Lordship. It was fixed for Commissioner report only from the online, Lordship.
Where is that order?
That order could not annex, Lordship, because I did not get the certified copy, Lordship.
Why?
Because I have applied for, Lordship. As I have taken. Lordship, kindly come page. The observation is, Lordship. Para 6, Lordship. Seen the pages that is 47, Lordships. On such perusal, seen the since so and so. Till date, the said cross-examination has not been completed. On so and so. Date adjournment was sought on the ground on so and so was gone to Bihar for so and so, and she is so and so made the submission. He is not having the brief. So cannot cross-examine the on that.
So this order appears to be a reason order
Lordship,
based on decision of
Lordship,
apex court.
Lordship,
Kindly see, Lordship, I cannot, the main ground was no medical document is because the council is suffering from fever, Lordship. Fever and cold, Lordship. He could not annex this medical document, that way it was closed, Lordship. And other, on that day, Lordship, we have,
That is the elementary thing that you have taken one ground in your petition,
Lordship,
and the ground is not supported by any document.
Lordship, that was true, Lordship, but fever and cold, Lordship, that ground was at. Lordship, here I said, on the ground, Lordship, the sufficient cause, Lordship, and the judgment, Lordship, of our High Court, Lordship. That sufficient cause can be. On the ground of Lordship Advocate or Lordship, the
No, not only that ground, but the ground, other grounds are also there.
that taken the
That
sufficient cause was not. Lordship, the
you have
judge,
been given sufficient opportunity.
Lordship, but the causes, the adjournment was granted on showing the sufficient causes, Lordship, for not appearing, Lordship. Kindly see, Lordship, the judgment, Lordship, in para 14, Lordship. Our High Court judgment, Lordship.
But the trial court has discussed a decision of Supreme Court.
Lordship, here also is one Supreme Court decision. Supreme Court decision has been in para 14. Salim Advocate Bar Association has been discussed where sufficient causes has shown. The paragraph 15, Lordship, from the registry.
But sufficient cause you have taken that medical ground, no medical document is enclosed.
Lordship,
Whether it will constitute the sufficient ground.
Lordship, for
Check
fever,
on heard Mr. Roy, learned counsel for the petitioner. In this petition under Article 227 of the Constitution of India, read with Section 151 of the Code of Civil Procedure, the petitioner has challenged the order dated 21/5/2025 passed by the learned civil judge, Junior Division number 1, Delaware, which in bracket, trial court, in PS number 30 of 2023. It is to be noted here that by impugn order dated so, the learned trial court has dismissed the petition number 4283 of 2025 filed by the petitioner herein on the ground that
no medical documents.
file a petition number 4283 of 2025 for adjournment on the ground that conducting advocate for the petitioner is suffering from fever and could not and is not in a position to come to the court to take cross-examination of the plaintiff. The Royal Learned Counsel for the petitioner submits that though no medical document was enclosed there, why you could not enclose the medical document?
Lordship, I am suffering, said this council was suffering from fever and cold, Lordship.
The Royal Learned Counsel for the petitioner submits that the counsel for the petitioner was suffering from cold and
Fever.
fever and cold. Fever and cold. And you have not taken any treatment under any doctor.
That was not taken, Lordship.
And he has not taken any treatment from any doctors. And therefore, no medical documents would not be enclosed. And that the petitioner has shown sufficient ground for adjournment, but without taking note of the same, the learned trial court has dismissed the petition and thereby close the cross-examination of PW1 and fix the next date on 19/6/2025 for evidence of PW. Mr. Roy further submits that considering the facts and circumstances of the case, the petitioner may be granted one opportunity for cross-examination of the PW1.
Lodge.
Having heard the submission of learned counsel for both the parties, I have carefully gone through the petition, the documents placed on record, and also perused the order dated 21/5/2025. And it appears that the impugned order so passed by the learned trial court suffers from no illegality or infirmity requiring any interference of this court. However, considering the submission of Mr. Roy learned counsel for the petitioner, and also considering the facts and circumstances of the record, this court is of the view that one last opportunity may be given to the petitioner to cross-examine the PW1. Accordingly, the impugned order dated 21/5/2025 stands interfered with and consequently the learned trial court is directed to afford another opportunity to cross-examine the PW1 by the petitioner. However, subject to payment of cost of rupees 5,000, the cost shall be deposited before the District Legal Service Authority, Dibrugarh, and produce the relevant receipt before the trial court or next day.
Lordship, tomorrow is
In
the
terms of this self-disclosure of that this motion is itself.
tomorrow is the next date fixed, Lordship. Tomorrow.
Before tomorrow, you put it there,
Lordship,
complete certificate of.
Lordship.
Will resume.
Admission, item 12, Arthur method.
Lordship. Lordship, the matter pertaining, Lordship, the provincial election, Lordship. So last question, Honorable, please to direct it to the elementary department, file annexer 1 to 3 of the state petition, Lordship. Annexer 1 to 3, Lordship.
And process.
For the plausible documents, Lordship.
Yes, Mr. Sharma, you received the document?
Lordship, just now I received some documents through WhatsApp and I took a printout also. Here, that so far as the dash data related, and enclosure 1 and 3 is there and 2 is missing, Lordship. So Lordship may fix tomorrow or day after. I will just confirm once. Otherwise, in so far as the dash data is concerned and that order, enclosure 3, it is there, but maybe they must be sending or that 2 is not there, Lordship. So
Who
Lordship
is
may
not
fix-
available?
Lordship, enclosure 1 and 3 I have received. 2 is missing here, Lordship. So Lordship
So
will fix
what
that.
does the 1 and 3 indicates?
Lordship, enclosure 1, my learned friend has already enclosed in the writ petition. Lordship will find that annexure 2 onwards, page number 18 to page number 30. These are the documents pertaining to enclosure 1 and 3. So that is the annexure, page number 18, annexure 2 is that DICE information system, DICE data capture form, data capture format. This is the enclosure, data capture format. And
Enclosure 3.
Enclosure 3 is that provincialization order which my learned friend has already annexed in page number annexure 3, page number 26 onwards.
Page number 26, which was provincialized lordship.
Provincialization order. So
Okay.
3 and 1 is there. 2 is here missing. I don't know. I have to just get a clarification. 2 is that inspection report, Lords.
Inspection report.
Inspection report.
That is important.
Yes, Lord.
That is otherwise this matter was confined to the dash data only. So insofar as the dash data is concerned, 2009-10 is necessary, and 9-10 there is only that the dash capture format, and 11-12 there is
You obtain this annexure 2,
Lordship.
enclosure number 2.
Lordship.
We'll say
The day after tomorrow, Lord.
Mr. Arsitas, learned counsel for the and learned standing counsel for the respondents, elementary education department. The SORMA submits that person to order dated 9/6/2025. He has obtained enclosure number 1 and 2.
1 and 3.
1 and 3 from the Block Elementary Education Officer, but he has not received the enclosure number 2. And as such, he prays that the matter may be listed on Friday. Where is according?
Only
The lordship, Monday lordship, if possible.
Monday?
Lordship, yes,
Okay.
Lordship.
otherwise your Lordship has hard on length. So only that. That.
That's a list of interest.
Item 13,
Yes.
Parker matter.
Master Lordship.
May it please, my lord. Pursuant to the last order passed by this honorable court, my lord, the respondent authorities were directed to produce the original service book, my lord, today.
So, Sarma, you have received the service book?
Lordship, I have received, in fact, which my learned friend is submitting. In fact, he has also claimed that he would be producing the service record, service book.
I also have a copy, my lord.
If your Lordship peruse the order, last order.
Yes, yes. I
Claimed
also,
that he would be producing the service record.
the one I
Otherwise,
have, I have to retirement, my lord.
I
I
have-
can also submit. My lord, I have flagged the relevant portion. My lord, the pink color flag, my lord, that is regarding my date of birth, my lord. And the green color flag, my lord, where I have recorded, that is regarding my service verified with effect from 1/7/21 to 31/7/22, which means that they have verified my services, then issued this. There cannot be any tampering.
Lordship, I will produce further some documents. Further documents are there. Lordship, my service book, Lordship may kindly peruse page number 3, serial number 7, date of birth. There is a report is also there at page number 25, part 2, Lordship. Page number
The
20.
petition?
Lord, the same service book, there is a yellow cover also.
Yes.
Page number 25, serially your Lordship will get. Where that report from the block 11 page has been noted. Page number 25. Now, Lordship, I will place another report, Lordship, from the director.
My lord, may kindly peruse my service book also, my lord, in the meantime, kindly. My lord, the first flag indicates my date of birth, my lord, that page 1/7/1962, which is the correct date of birth. And my lord may kindly peruse the green flag as well, the last page. There it is written service verified. It is written by them, my lord. Signature is also there of the authority. One from 1/7/2021 to 31/7/22, my last day. That means they verified and then issued. And everything is okay, my lord. When, my lord, everything is okay, now they are alleging that there is overstay of 2 years. That is my case, my lord.
Yes.
Lordship, that communication just I have placed before Lordship. There is a communication I have just placed before Lordship. The communication to the Lordship, this letter. This was given to the petitioner insofar as related to the provisional pension. Now, this communication is of 7/11/2023. Lordship, may I read the communication? To Sri Narendranath Barua regarding uploading your personal details in the Kritagyata portal for processing your provisional pension. For processing this provisional pension, there is a portal Kritagyata. So the petitioner himself has to upload his personal details in that portal. Now, order of the honorable court dated 27/9/2023, WPC number dispatched with reference to the subject cited above. I am to inform you that for providing your provisional pension, we have already registered your name in the Kritagyata portal, and the system generated user ID and password have already been sent to you, sent to your mobile number. Now, as per rule, you are to upload your personal details, pensioner's part, in Kritagyata portal for process of your provisional pension. Accordingly, you are directed to take necessary action from your end. Now, let's see next page. This is a form 33. This has been uploaded by the petitioner himself. Name of the government servant, Narendranath Barua. This is submitted by the petitioner, uploaded by the petitioner. Name of the government servant, Narendranath Barua. Designation headmaster. Serial number 3, date of birth, 1/7/1960. What's the kindly peruse? 1960. Details of family, so and so. Now declaration. I hereby undertake to keep the above particulars up to date by noting to the audit officer, head of office, of any addition or alteration. So this data, and now the signature, Lordship, signature of the government servant. This is Narendranath Barua. So these particulars have been uploaded in the Kritagyata portal by the petitioner himself, stating his date of birth as 1/7/1960. And the remaining other details, Lordship. So this particular details has been uploaded in the Kritagyata portal for provisional pension by the petitioner himself, stating his date of birth as 1/7/1960. Now, Lordship, insofar as that date of birth in his admit card and that report form, I will place another report from the SEVA. In fact, the petitioner has appeared his HSLC exam in 2 occasions. One occasion he failed. Second occasion, on some supplementary he passed. On both the occasion, his date of birth as provided by the SEVA. Lordship, kindly present, Lordship. Communication dated 7/6/2024 from Soman Kasari, Deputy Secretary, Board of Secondary Education, so and so, to the Suranjana Senapati, Director Elementary Education, Assam, verification, your letter number so and so, dated so and so. With reference to your letter cited above, I am directed to inform that the documents, original photocopy of the candidates which you sent for verification is are verified and found as shown below against the roll numbers and the year of examination as per record of this office. Serial number 1, roll 704, number so and so, year 1979, exam HSLC, Narendranath Borua, age 18 years, 8 months as on 1/3/1970. Meaning thereby, his date of birth is 1/7/1960. If he is 18 years, 8 months in 1/3/1979. Result failed. On the first occasion, he failed. Remarks eligible for supplementary exam, supplementary in GM. Now the second lordship. Second, roll so and so 255. This has been shown by the petitioner. Year 1979, HSLC, Narendranath Borua, age 18 years, 8 months, as on 1/3/1979. Pass, this time he passed, as per record. So this report has been sent by the Seva upon inquiry, lordship. Now, even lordship may kindly peruse the affidavit filed by the Seva. Chairman Seva has filed an affidavit, your lordship will find at page number, running page is 97 onwards. I will lordship.
Page number?
Page number 97. Is the affidavit. Filed by the Chairman, Board of Secondary Education, Assam. And the relevant page is page number 98. Paragraph number 4.
Yes.
Where it lordship? That the deponent begs to state that the board has verified the admit card, lordship may kindly note, admit card and pass certificate issued to the petitioner with records of the board and following particulars are found. Roll H number 255, which the petitioner has shown in his petition of HSLC supplementary examination 1979. Candidate's name Narendranath Borua, father's name Munindranath Borua, age 18 years, 8 months, age on 1/3/1979.
My lord, may kindly read the entire paragraph.
Let him.
Don't interrupt him with it. Therefore, lordship, 8 years, 8 months, as on 1/3/1979, meaning thereby his date of birth as is 1/7/1960. Which my learned friend is also there. He will submit.
My lord, I was just butting in, my lord, because the paragraph which was referred to my senior, my lord, that paragraph only. My lord, may kindly read the paragraph in totality, my lord, then things will be
Yeah,
clear.
that's all right. We'll read it. Let him complete. Your part is over.
No, lordship. I will submit two more things, lordship. Now, lordship, I will take back to my affidavit, lordship, that department, filed by the department. Page number 60.
Yes.
Lordship, that with regard to the statement made in paragraph 2 of the read petition, the answering department begs to state that the petitioner joined in the so and so 1991, 1911, 1991. The then block elementary education officer, South Block Sarupathar, sent a retirement notice to the petitioner on 1/6/2020. Your Lordship will find this notice on page number 66 of my affidavit, Lordship. Page number 66. From so and so block elementary education officer to Narendra Porwa, so and so. Sir, on verification of your service book and as per letter number so and so dated 31st October 2012 issued by the Commissioner and Secretary Government of Assam, your date of retirement falls on 31/7/2020. Therefore, you are hereby intimated to hand over all the documents, papers under your possession and also deposit the government money lying with you, if any, in the school fund systematically to the senior-most assistant teacher in the afternoon of 31/7/2020 and go on retirement. In addition, you are also hereby intimated to submit all the relevant papers, documents related to the pension to the district elementary education officer Golaghat as soon as possible. So this notice has been issued on 1/6/2020 stating that he is going to retire on 31st July 2020. 2 months after. This notice has been, Lordship, kindly note, 1st June 2020, the notice has been issued. 31st July, he is going to retire. So well ahead of time, 2 months time has been given, 2 months time has been given to him for retirement and to submit his pension documents for the pensionary benefits and etc. Now, Lordship, pursuant to this letter, the petitioner at page number 69, Lordship, my kindly 69. He replied to the letter, that retirement letter sent to him by the BEO. Letter dated 17/7/2020. Vernacular to the block elementary education officer Golaghat, South Salmara block, Sarupathar. Your letter number so and so dated 1/6/2020. Sir, with due respect, I beg to state that as per your office letter, I have been asked to go on retirement on 31/7/2020. But in my HSLC admit card and pass certificate he has mentioned here, and in all the documents, he has also stated that pass certificate as well as all the documents, he is claiming that his date of birth is recorded as in the office, date of birth is recorded as 1/7/1962. It is a fact that my date of birth is 1/7/1962. In this regard, I have submitted an affidavit. I hereby clarify you that the date of birth recorded in my high school certificate issued by the board is not correct. Date of birth recorded in admit card is correct. Now he is claiming that the date of birth recorded in admit card is correct, which the SUBA has already clarified that in the admit card also his date of birth is 1/7/1960. Now he is claiming that the date of birth submitted by mentioned in the certificate is not correct. Therefore, I request you to allow me to continue in service till 1/7/2022 and oblige. Furthermore, there will not be any discrepancy in my date of birth, and I will be responsible, Lordship. I will be responsible for any discrepancy. This is my humble prayer. So this statement, along with the affidavit, Lordship, my learned friend, the petition has furnished. Now,
Where is the affidavit?
That is part of the writ petition.
Part of the writ petition, my lord may have it at page, my lord, 24, my lord.
Page number?
24 of the writ petition.
Page number 24, Lord.
Yes.
Page number 25. I, Sri so and so, son of so and so, so and so, so and so. Paragraph 1. That as per my horoscope, and admit card of SSLC examination. My age is recorded as 16 years, 8 months on first day of March 1979. Number two, that in all other educational certificates, documents, as in the service book, my age has been recorded as 16 years, 8 months, 8 months, which is correct. Number three, that in the original SSLC pass certificate issued by the Board of Secondary Education Assam, my age on 1st of March 1979 has been wrongly recorded as 18 years, 8 months. I play in place of 16 years, 8 months. 4, next page, Lordship. That in fact my age as entered in the SSLC admit card and other educational certificate is correct for all purposes. That this affidavit has been executed for the purpose of submitting before the authority concerned. So this affidavit he has shown, claiming that his age as on 1/3/1979 to be 16 years,
8 months.
8 months. Now, Lordship, this affidavit. My affidavit, again, I will take your Lordship to my affidavit. Lordship. Paragraph number 7, Lordship, page number 61. That with regard to the statement made in paragraph 3 of the writ petition, the answering deponent begs to state that the district elementary education officer Golaghat has asked the petitioner to provide the original SSLC pass certificate to verify his actual date of birth, as two different date of birth were found in the SSLC admit card and SSLC pass certificate. Paragraph number 8, that with regard to the statement made in paragraph 4 of the writ petition, the answer will humbly be stated that in order to confirm the actual date of birth of the petitioner, the district elementary education officer Golaghat on 13/3/2022 had sent the SSLC pass certificate and the admit card to the chairman Seva Assam, and in reply, the Seva verified communication dated 22/3/2000, earlier occasion also, 22/3/2023, confirmed the actual age of the petitioner being 18 years, 8 months as on 1/7/19, which means the petitioner attained the age of superannuation on 31/7/2020. Now this report, your Lordship will find at page 72. Two, the report from the Seva Lordship. The one which I placed now is the second report. This is the first report. Dated Guwahati, that 22 March 2023. Verification, your letter number so and so. With reference to your letter cited above, I am directed to inform you that the information regarding the age of Narendranath Barua sought by you by your letter under reference number so and so above is furnished below as per record of this office. Roll number that roll age 255, 1979 examination HSLC supply, the second examination. Narendranath Barua, age 18 years, 8 months. As on 1/3/1979, result pass, remarks as per record. Therefore, this report also confirmed that the age as on 1/3/1979 is not 16 years, 8 months, but it is 18 years, 8 months. Which means his date of birth is 1/7/1960 and the date of retirement is 31/7/2020. Thereafter also, Lordship, my learned friend has claimed that another notice was served on him. So, Lordship, may kindly peruse paragraph number 8. I'm sorry, paragraph number 9. Page number 62.
Page number
62 of my.
Yes.
That with regard to the statement made in paragraph 5 of the writ petition, the answering deponent begs to state that subsequently on 25/4/2022, which my learned friend had claimed in his made a contention in the writ petition that he was served a retirement notice on 25/4/2022. Under what circumstances this notice was issued, it has been clarified, Lordship. On 25/4/2022, the Block Elementary Education Officer, South Block, Sorupathar, sent a retirement notice to the petitioner because of the fact of misleading with malified intention on the part of the petitioner by giving false undertaking and affidavit. This undertaking and affidavit which my learned friend have shown the Lordship with malified intention and misrepresentation. So because of the malified intention and misleading, because of the act of misleading with malified intention on the part of the petitioner by giving false undertaking and affidavit, because he overstayed for 2 years, Lordship, by giving this undertaking that he is responsible for any discrepancies, and he has sworn an affidavit claiming his date of birth to be 1962. Now subsequently that Lordship, there is another contention of the petitioner that he was issued non-liability certificate. So insofar as that non-liability certificate is concerned, Lordship, that clarification has been made at paragraph number 10. That with regard to the statement made in paragraph 6 of the writ petition, the answering deponent begs to state that Block Mission Coordinator provided a non-liability certificate to the petitioner only for SMC account and midday meal account operation related issues, but not on the basis of teachers' salary and age related issues. However, the said certificate was cancelled by the DO South Golaghat, so by order dated 2/5/2023, which has been annexed as Annexure 5, page number 73 of the affidavit. Page number 73. The non-liability certificate issued by this office by number
Page number?
Lordship.
Page number?
Page number 73. 73. of the affidavit.
Yes.
Annexure 5. Order dated 2/5/2023. The non-liability certificate issued by this office, order number so and so, dated so and so, 1/11/2022, are hereby cancelled with immediate effect due to his liabilities of excess salary received by him with effect from 1/8/2020 to 31/7/2022. Now, I will take back to page number 63 again, Lordship. Paragraph number 11. That with regard to the statement made in paragraph 7, 8, 9, 10, and 11 of the writ petition, the answering deponent begs to state that the petitioner himself admitted on 27/7/2020 that there is a discrepancy in his date of birth in both SSLC admit card and SSLC original pass certificate, and thus prayed for continuing in process for pension on the basis of the date of birth recorded in the SSLC pass certificate, because of which DEO Golaghat communicated a letter on 29/5/2023 to the petitioner stating that there is no similarity in the date of birth of the petitioner in his Aadhaar and PAN card with SSLC pass certificate. So there is a discrepancy. The petitioner was claiming that in all the documents he has the date of birth recorded as 1/6/1962, but Aadhaar card, PAN card, and my learned friend has also not included those documents with the petition. There is no the Aadhaar card, PAN card. It's not part of this petition.
Petition who annexes Aadhaar card?
If he claims that all the documents are his date of birth is recorded as 1/6/1962, in that case he has to annex all these documents claiming his date of birth as 1/6/1962. So he has not annexed. But till that the petitioner has not replied to the DO Golaghat, and consequently his pension proposal could not be processed by the office of the DO Golaghat, since the pension related works are done online. It is not possible to proceed if there is a dissimilarity in the date of birth in the documents provided by the applicant. Further, it is to be mentioned here that the petitioner has misled the office and already overstayed for 2 years from his actual date of superannuation. So he had excess drawn his salary for 2 years by misleading the office with malified intention. Hence, the excess drawl amount will be recovered from the petitioner. Paragraph number 12 or page number 64. With regard to the statement made in 13, 14, 15, 16 of the petition, the answer given begs to state that the petitioner had misled the office by submitting wrong documents, and accordingly he has made overcharge his duties for 2 years and excess salary also drawn from the government exchequer. And due to discrepancy of his date of birth, it is not possible to process his pension and pensionary benefit. Paragraph number 13, Lordship, with regard to the statement in paragraph 17 and 18 of the petition, the answer given Honorable Speaker, while denying the averments made herein, begs to state that it is not true that the authorities has not released the pension and pensionary benefit to the petitioner by violating the principles of natural justice. The petitioner has misled the office by submitting wrong documents, and accordingly he has made overcharge his duties for 2 years, and excess salary is also drawn from the government exchequer. And due discrepancy of his date of birth, it is not possible to process the pension payment. Therefore, Lordship, as I have already that report of the Kritagata portal I have placed before your Lordship, where he has himself uploaded his date of birth to be 1/7/1960, that I have already placed before Lord. Therefore, Lordship, here the petitioner has not come with a clean hand, and Lordship, with malified intention, he has filed this writ petition, therefore is liable to be set aside and quashed. Now, in support of my argument, Lordship, I would like to place some judgment, Lordship, of this honorable court and also of the honorable apex court, Lord.
Yes.
That's my 2014 to 2514, the first one, Lordship. Anadhir Ranjan Paul versus State of Assam and others.
Which is the relevant paragraph?
Lordship,
Relevant paragraph.
relevant paragraph here is 9, 8 is also relevant, but 9, 10, 11, and 11, 12, and 13, Lordship. May I read, Lordship? May I read, Lordship? Paragraph.
Not required.
Lordship. And there is another WPC number 4645 of 2024, passed by this honorable court, the court was Pilot Justice Michael Totan Kumar. Here also, Pulatan Gogoi. In fact, in this writ petition, Lordship, in this order, Lordship, all the other citations has been discussed, Lordship. From paragraph 21 onwards to 30, Lordship. Another writ petition, Lordship, WPC number 4888 of 2024, Niran Gogoi. My Lord Justice Michael Jotan Kumar, Lordship, order dated 25 to 2025. Similar order, Lordship, where here, Lordship, that recovery has been allowed, Lordship, because of the misrepresentation by the petitioner and misleading and with malified intention, he has overstayed for 2 years. So this, and even Lordship, that 2009 3 Supreme Court SCC 117, the Pandey Jagadish Prasad, Lordship, these issues has been discussed in paragraph number 22, 23, 24, and 30. My learned friend has relied basically on Rafiq Mashi case. My learned friend was submitting about the Rafiq Mashi case. In fact, this Rafiq Mashi case is different from that Pandey Jagadishwar Prasad. Rafiq Mashi basically in regard to the wrong fixation of pay. And Pandey Jagadishwar Prasad is in relation to the overstay in service. And even in the Rafiq Mashi case, Lordship, where there is a misrepresentation, fraud on the part of the petitioner, that cannot be, that can be, that excess draw can be recovered. So if there is no fault on the part of the incumbent, and if there is no misrepresentation of fraud or malified intention, in that case, recovery cannot be done. But if there is a misrepresentation, malified or fraud on the part of the petitioner, in that case, there is no bar now. So these are the citations.
So Rafiq Mas's, the law laid down in Rafiq Mas's case will not be applicable in the present case.
Otherwise, Lordship, this is Rafiq Mashi primarily dealt with the wrong fixation of pay. And even Lordship sees that 2009 3SCC 117 I placed before Lordship, Pandey Jagadishwar Prasad. This is more relevant because this has been dealt with regard to the overstay in service. And the case of the petitioner is overstay in service. By producing a fake, I should not say, but by misrepresentation, by wrong date of birth, by misleading the department. So this Pandey Jagadishwar Prasad is more relevant in this matter, Lordship. Even in the Rafiq Mashi case also, Lordship, that if there is a misrepresentation and fraud or malified intention, there is no bar to recover from the. If there is no fault on the part of the petitioner, then the recovery cannot be made. That has been stated in the Rafiq Mashi. That has also been dealt in the writ petitions which has been passed by this court in the bench of this honorable court now. And Lordship, in fact, there is a report I have received from the director also, which goes to show that in so far as the provisional pensions could not be approved, pension proposals could not be processed through Krityagata portal that he has uploaded, stating 1/7/2020 as 1960 being his date of birth. Due to discrepancy in the date of birth in the SSC certificate, Aadhaar card and PAN card, and the report has been submitted by the chamber. So this is my humble submission because the petitioner has not approached this honorable court with clean hand and with bona fide and with suppression of fact also, Lordship. Therefore, this writ petition is liable to be set aside in court. And the department be allowed to recover the amount overdrawn during that period from 1/8/2020 to 31/7/2022. This is my humble submission also.
Okay. Yes, any other respondent?
But I'm appealing for several matters. We have filed our affidavit. Not the date of birth of the candidate recorded on the basis of statement of particulars provided by the headmaster at the time of appearing in the SLC examination. My lord, kindly see the statement, my lord, provided by the school at page 100 of our affidavit. I copy, my lord. Roll.
Yes.
Roll, my lord, 334, name Narendranath Borua, age on 1/3/79, 18 years, 8 months, 0 days. This is recorded in the birth certificate. And here stipulation registers also, my lord, at page 103, my lord. Supplementary, my lord, examination 1970.
Serial number.
Serial number, my lord, is roll, my lord, 255. Here, my lord, against Narendranath Burwa, age on 1/79, 18 years, 8 months, 0 days. It is 1/7/1960. My lord, therefore, my lord, his date of birth is 1/7/1960 as per the statement of particulars provided by the headmaster at the time of in the exam.
So any other respondent? No.
Make us only submission here, what I have learned, Lordship, because the education department, they are the employers, Lordship. So here from what I have understood, Lordship, he is making a prayer for releasing of pensionary benefits. From what I've understood, he has not completed the procedure that is required to complete the pensionary benefits. Regarding submission of relevant documents, Lordship. Rafiq Masik and all, Lordship, that my learned friend has already stated. But in order to this entire writ petition, he has filed for releasing without completing all the documentations, and that my learned friend has already submitted. So that is itself, in a way, Lordship, this prayer, the prayer which my learned friend has made, it is premature because he has approached the court instead of approaching the authorities. So there is a issue regarding the respondents to process the claim of the petitioner also. Without completing the entire process, Lordship, he has come to the writ court praying for a direction and the relevant documents which are required.
He has not submitted those documents.
Those, not all, Lordship, from what I have learned, what my learned friend is, some of certain verification needs to be done as there is some age declaration. For that, he has to approach the authorities. Instead, he has approached the court, Lordship. So Lordship will keep that in mind also, because his entire process for finalization of pension, he has to complete on his own. And for that, the verification that needs to be done, he has to cooperate with the department. Here is a case where he has approached the court, directing the praying for a direction from the court to release the benefits. But we as a state, we have a duty to verify also, Lordship. And upon verification, the questions, here is a question where there's undertakings given where he is a government servant and there are wrong undertakings given, from what I have understood, Lordship. So keeping all those things in mind, Lordship will take a decision, Lordship.
Yes.
Before my learned friend starts, Lordship, I will take your Lordship to SR 8 once, because
Okay.
if your Lordship has this book.
Yes, sir.
Itu kita pasti.
Yes.
SR 8, Lordship. A is not relevant for us. Even B also not. C, Lordship. Our Lordship.
SR 8.
SR 8.
Okay.
SR 8 C plus C. Lordship. Commissioner and heads of department may alter the records of date of birth in case of non-gazetted government servants, provided they are satisfied after inquiry that the previous date was incorrect. Now note, Lordship, non-gazetted government servant, which the petitioner is, Lordship. The head of the office should record the date of birth in the service book of a non-gazetted government servant on his initial appointment with reference to the matriculation or equivalent certificate. So date of birth is authenticated by metric certificate, the HNCC certificate. That point I just wanted to clarify also. Not the admit card. That clarification has already been made in the affidavit filed by my learned friend on behalf of Chairman Seva. So matriculation certificate is the authenticate document to prove the date of birth loss.
My lord, may I? Yes, my lord, may kindly have SRHC for a moment again. My lord, the provision which my senior friend was referring to. Oh my God. My lord, one more respondent left, my respected senior.
I'm very sorry. I'm from Accountant General. I'm for Accountant General. Ma'am. Basically, we have as of now nothing to say unless this issue is solved. If at all, after this issue goes to Accountant General, we'll have our role. As of now, we have.
My lord, HC, my lord has. May I again read, my lord, what my senior friend had just read? Non-gazetted government servant, the head of the office, should record the date of birth in the service book of a non-gazetted government servant on his initial appointment with reference to matriculation or equivalent certificate. Yes, my lord, matriculation is there, but equivalent certificate being the admit card in the instant case. No, my lord, that is subject to interpretation. They cannot trash it out, my lord, the respondent authorities. Matriculation or equivalent, then they have to give it in oath that this statement equivalent certificate, they have to challenge the rule then.
No, whether the admit card can be considered as certificate.
My lord, this is silent on this equivalent certificate. My lord, equivalent certificate, to my humble understanding, my lord.
Equivalent certificate, whether the admit card can be considered as equivalent certificate.
And my lord, Act is silent on that. They should have clarified what would constitute a equivalent certificate. That is one point, my lord. Now, my lord, I would kindly refer to the affidavit filed by Seba, my lord. If my lord would kindly have page 99, which my senior from Education Department had also referred to that point at page 99, my lord. 98 it starts. That the deponent begs to state that the board has verified, paragraph 4, my lord, 98. Verified the admit card and pass certificate issued to the petitioner with the records of the board, and following particulars are found. Roll number 25, HSLC supplementary examination 1979, 18 years, 8 months, so many days, 1379. Particulars of a candidate, including the date of birth, age, are preserved in the office record, MRS and TR. On the basis of these particulars, HSLC pass certificate are issued. In the board's record, MRS and TR, the age of the petitioner is found as 18 years, 8 months, 00 days on 1379. Hence, the board has rightly recorded the age of the petitioner as 18 years, 8 months, on 1379 in the pass certificate. Regarding the admit card, my lord, this is pertinent. Regarding the admit card, next page, my lord, it is to clarify that during the time admit card were being written in school level, and there was maximum probability of wrong recording. In case of the petitioner also, it happens that in the HSLC admit card, his age was recorded as 16 years, 8 months, 00 days as on 1379 in place of 18 years, 8 months. Now, my lord would kindly have my admit card, which is at page 20 for a moment, my lord. And moreover, they have said it's probably wrong. They are not saying that it is wrong. They are saying probably, based on some probability. They'll decide my future.
Page number
20, my lord. My lord would kindly have the bottom portion of the page, my lord, page 20. My lord, assistant officer seal, my lord. The principal seal is also there and controller of examination is also there. Both are there, my lord. It has been verified. It is not like only the principal had issued it. Better page 20, my lord. So, my lord, it is not like the issuing authority is only the principal, the headmaster.
verified it.
Yes, my lord, because the sign of the controller of examination is also there. Mr. Casey Das, the Casey Deca, sorry. My lord, their claim that the admit card was issued from the school cannot be sustained, my lord. Because admit cards are issued by the controller of examination, my lord. Any board, my lord. This is not a correct statement made by my
Whether you have filed any reply to the
yes, my
affidavit
lord,
filed by them.
I filed. My lord, may kindly have my affidavit in reply at page, my lord, 74 onwards, my lord. My lord, can I kindly demonstrate my case from the start, from my petition? Because My friends have also, senior friends have also. I may also demonstrate it from the beginning. My lord would kindly have my writ petition.
No, in which paragraph of your affidavit in reply, you have disputed the claim made by the SEBA?
Yes, my lord. It is there, my. No, SEBA's affidavit, I have not filed a reply, but affidavit of the Director of Elementary Education, I have discarded. My.
No. Who is the authority? SEBA is the authority.
SEBA is the authority.
So you have not disputed the claim made by them in their affidavit.
No, my lord.
So
Against
the
the
same remain uncontroverted.
My lord, against the SEBA's affidavit, I have not filed a reply because, my lord, the said affidavit is itself, my lord, not clear, my lord, regarding my age, my lord. Because that probability part is
No,
there.
no, maybe
Yes.
you have not disputed it.
But then, my lord, I will dispute it.
In their affidavit, they have taken a stand regarding your date of birth, and you have not disputed the same.
My lord, regarding my date of birth, my lord, I have disputed it in my affidavit in reply to the affidavit filed by the Director of Elementary Education. May I kindly take my lord to that affidavit, my lord? Page 75, my lord, has it starts, my 76, my lord, the relevant portion is start. My lord, first of all, the retirement notice, my lord, which my senior friend had also referred to from the Education Department. I got the notice on 1/6/2020, my lord. Yes, on 1/6/2020, to which I had filed my reply on 17/7/2020. My lord, would kindly have the pension manual for a moment, my lord. On the last occasion also I made references, but I'll make again, my lord. If my lord has Rule 95, pension manual, my lord. Yes, yes, my lord. I'll just start, my 95. Yes, my my lord has found page Rule 95, my lord.
Yeah.
I'll just
Procedure.
Yes, my lord, the procedural part. My lord, it clearly states that all these formalities regarding the notice for retirement, if my lord peruses it, it should be sent ahead of 1 year before the person retires. Now, my lord, they had sent me the said notice on 1/6/2020. Assuming that I have to retire on 1/7/2020, that is a procedural lapse on the part of the respondent authorities. Only 2 months ago, I had got it. My lord knows that before a person retires, he has to undergo a lot of procedural process. He has to visit the accountant general's office, then he has to submit his documents so that his pension papers get processed in time and everything, my lord. So that his pension is released to him without any haphazard. Now, my lord, just 2 months ago, they had sent it, my lord. Just 2 months before my retirement, which they are claiming.
No, but Mr. Sharma, it appears that you have not completed the process.
No, my lord, the documents which were asked by the
Unless you submit your pension papers, how the authority will proceed?
My lord, the papers which were asked by the responding authorities prior to my retirement, I had given. Now, my lord, the paragraph which my senior friend was referring to regarding the Aadhaar card and PAN card, that was sought from me during the case was going on, and I have given a reply to this. My lord would find it.
You see, without completing the process of filing the pension paper, you have approached this court. How can we issue direction to them that you complete the process?
My lord, I have got instructions from my client that all the documents that were sought for prior to my retirement, that I have given, because before a person retires, gives all the documents. When the case was filed, my lord, they had asked for the said Aadhaar card and PAN card, to which I have sent a reply. If my lord has page, my lord, at 95, my lord, of my reply, page 95. '93, my lord, it starts, my lord, 93. The letter issued by the respondent authorities.
Yes.
This was 3623. This is to inform you that as per the letter of this office, white number so and so, dated 29/5/23, you were notified because your information was not matching, but we didn't get a reply or any information. For this reason, we can't start your pension related work, so we again request you to submit the correct information. It is an admitted fact. To this I reply, my lord, at page 95. It is to inform you at 95, my lord. It is to inform you that with reference to your letter number so and so, dated 36/23, I would like to inform you that I have already approached the Honorable Guwahati High Court by case registered and numbered as 2697 of 23, and the matter is sub judice. The matter being currently sub judice, my lord, whatever.
Sub judice, you filed it before the cause of action arises in your favor. You come to paragraph, page number 12.
Yes.
Of your writ petition.
Yes,
regarding the pair.
Yes, ma'am.
To direct the respondent to forthwith release the retirement benefit of the petitioner.
Yes.
To which he is entitled to on his retirement from service.
Yes.
And
31/7/20.
to issue direction for payment of appropriate interest as per bank
norms on the delayed payment of the said benefit.
and regarding the relief and other reliefs to which the petitioner may be entitled to. But you have not completed the process. You have not submitted the relevant documents.
No, my lord, my bone of contention is that after this case had started, they had sought for certain documents which they did not seek prior to my retirement. My lord, the mandate is that prior to my retirement, they should have sought for the said documents. Now, when the case had started, I started getting my provisional pension also, my lord. I had to file a contempt case also, my lord, but I will not go into that. Because my provisional pension was not being released, then I had to file a contempt case. I got it eventually. Now, my lord, in the contempt case also, I have a copy of the instructions, my lord, if I may submit, ma'am.
That contempt case has already been closed.
That is closed, my lord. That is closed. And my lord, pursuant to that, my lord, I was not getting my provisional pension. That is why I had to file. Those documents, my lord, the Aadhaar card and PAN card, the certain documents they are referring to that I have already uploaded in my Kitagyata portal, my lord. Kitagyata portal account, which I was told to upload my documents pursuant to the compliance order of the contempt case. I had done, and I had accordingly got my provisional pension also, my lord. It is not a case that I have not submitted my documents. And regarding the Kitagyata portal, that my date of birth is 1/7/1960, which my senior friend had referred to and also submitted one document. I'll have to seek some clarification over this. I'll take it over the telephone, my lord, during this lunch break.
Okay. In the meantime, you obtain
Yes, my lord. I'll just,
resume at 2 o'clock.
yes, my lord. I'll just obtain the. My lord, I would like to hand over a few documents, my lord, with the permission of this honorable court. My Aadhaar, PAN, my driving license, and everything. There, my date of birth is correctly reflected. 1/7/1962.
When this was obtained?
My lord, Aadhaar, my lord, after 2019, and PAN card, and it's prior to my retirement. My lord, and one more notice I have, my lord. My lord, the Kitagyata portal issue, my lord, where my senior friend had said that I had submitted that 1/7/1960 by myself. I have got telephonic instructions from my client stating that that can be, my lord, altered by the respondent authorities who are in control of the Kitagyata portal. And also, my lord, I had intimated them through this notice, telling them that in my Kitagyata portal, in fact, there is an endorsement, there is a seal and signature of the District Elementary Education Officer, Golaghat. They have received it.
No, you tell me on which that you have obtained this driving license?
My lord, this was prior to my retirement.
Prior to your retirement?
Yes, my lord.
Okay.
1722 prior to my retirement. And Aadhaar after 2019 after the NRC access.
Prior to retirement, and it is PAN card.
All prior to our retirement, to my
Prior
retirement.
to, all prior to
All
your
prior to
retirement.
retirement, all prior to 1722.
Okay.
My lord, this is the notice, my lord, I had sent to the, there's an endorsement that is not so clear, my lord, because I've just got photos just now.
Hmm.
My lord, it has been received by the District Elementary Education Officer, Gulaghat.
Hmm.
I had intimated them that in the Kritagyata portal, my date of birth is being wrongly shown. Although I had entered it as 17-1962, but it is getting reflected as 17-1960. I had sent them this.
Whether they can do it.
My lord, that is the information I have got, that it can be altered.
It can be altered.
Can be altered. Details. And it is with them. My lord, my
Yeah,
lord,
Mr. Sharma, is it possible to alter the
My learned friend is,
documents uploaded in the portal?
that cannot be. That is why, Lordship, that correction cannot be done, because this particular format is to be uploaded exclusively by the petitioner himself, the government, concerned government servant himself. That cannot be added or altered by the department. That is why, otherwise that department would have themselves uploaded it. Because this particular format has to be uploaded, verified, and prove the signature in there itself. So that cannot be altered. That is a wrong submission placed.
that is the
Advanced by
instruction
my
I got.
friend.
Instruction I got from the clients.
Okay.
It can be altered. I am also not very well versed, my lord. I've just got instructions on that point.
Okay. Okay.
Just my lord, then my lord, I will continue with my submissions. My lord, let us take for example that, let us take, my lord, that I have overstayed. Let us take for example. But can they recover that amount? No, my lord. Rule 21 saves me. Rule 21 of the pension rules. My lord, may kindly have Rule 21 of the pension manual, my lord. As per law, they cannot recover, my lord.
Rule 21.
Rule 21, my lord. And there are
Yes.
Supreme Court judgments and this Honorable Court's judgment as well on this point. May I read, my lord?
Who is Supreme Court judgment?
My lord, I will like to hand it over, my lord. My lord, State of UP and another versus Sri Krishna Pandey. And my lord, there are other judgments as well. I'll just hand it over to, and my lord, this Honorable Court's order, Sushil Kumar Borua. Then my lord, Daksha Prasad Deka, that show cause notice and opportunity has to be given in such kind of cases where there is discrepancy regarding birth, date of birth. And my lord, Bhanwari Singh Bhup Singh Rajput. This also says, my lord, opportunity to prove the age has to be given. My lord, may I kindly hand over with the Honorable Court's permission. My lord, may I read Rule 21 first, my lord? Then I'll take my lord to the judgments, my lord. The Governor of Assam reserves to himself the right of withholding or withdrawing a pension or any part of it, whether permanently or for a specified period, and the right of ordering loss caused to the government if, in a departmental or judicial proceeding, the pensioner is found guilty of grave misconduct or negligence during the period of his service, including service rendered upon re-employment after retirement, provided that such departmental proceeding, if instituted while the officer was in service, whether before his retirement or during his re-employment, shall, after the final retirement of the officer, be deemed to be a proceeding under this rule and shall be continued and concluded by the authority. Explanation. The continuation of the proceeding after the final retirement of the officer shall be automatic under sub-rule A of Rule 21, and no fresh decision of the governor/appointing authority, nor any show cause notice to the person concerned shall be necessary. The powers under Rule 21 shall be exercisable not only in case of causing pecuniary loss to the government, but also in other cases. Such departmental proceeding, if not instituted while the officer was in service, whether before his retirement or during his re-employment, shall not be instituted, save with the sanction of the Governor of Assam, shall not be in respect of any event which took place more than 4 years.
Is it your case that any disciplinary proceeding was instituted against you?
No, my lord, they should have
Then-
conducted an inquiry. In fact, there is an order passed by this honorable court, 29/5/24 order, where this honorable court had sought for information whether any inquiry was. My lord, they may conduct an inquiry. They have to give me a show cause notice. I'll reply, I'll appear. Then they can do it, my lord. Then they can carry out such recovery. But without doing that, without carrying on the due process of law, how can they today, after I've retired, come and say that you have stayed for 2 years, we'll recover it from your dues? That cannot be the case, my lord. In fact, my lord would kindly have the first judgment, my lord. State of UP and another versus C. Krishna Pandey. My lord may kindly have the flag portion, my lord. Paragraph 6, my lord. If I may read, my lord.
Yes.
It would thus be seen that proceedings are required to be instituted against the delinquent officer before retirement. There is no specific provision allowing the officer to continue in service, nor any order passed to allow him to continue on re-employment till the inquiry is completed, without allowing him to retire from service. Equally, there is no provision that the proceedings be initiated as a disciplinary measure, and the action initiated earlier would remain unabated after retirement. If regulation so and so is to be operative in respect of pending proceedings, be by necessary application, prior sanction of the governor to continue the proceedings against him is required. On the other hand, the regulation also would indicate that if the officer caused pecuniary loss or committed embezzlement, etc., due to misconduct or negligence or dereliction of duty, then proceedings should be instituted after retirement against the officer as expeditiously as possible. But the event of misconduct, etc., which may have resulted in the loss of the government or embezzlement, the cause for the institution of proceeding, should not have taken place more than 4 years before the date of institution of such proceeding. 4 years, my lord. Cause of action arises from 1/6/2020 in the instant case, because I got that notice on 1/6/2020. So 1/6/2024, before that, they could have. Now the boat has sailed, my lord. They cannot conduct any inquiry. They cannot do the recovery. Let us assume that I have
regarding your actual date of birth also, they cannot conduct any inquiry.
No, my lord, the time has gone, my lord. Like this, my lord, they can do it any day. Tomorrow I'll become 80. Then they will say you have stayed for so many years. Now we'll do it. Then tomorrow I'll become 90. Then also they'll say. That is why the
No, Mr.
legislators have
Verma,
come with
you
this
see,
period, my lord, 4 years.
They have, before your actual date of retirement, they have given notice to you.
Yes, my lord. But that was 2 months prior.
And then you have given your undertaking.
Undertaking in the sense that, my lord, I have given them a reply that this is my real age of birth, correct age, which is reflected in my admit card, and it is wrongly instituted in my HSLC pass certificate. So I told them that at that time they could have conducted an inquiry. It's not like I have suppressed
Since
anything.
you have given the undertaking, this decision of Supreme Court in the case of Rafiq Masih would not help you.
No, my lord, I am not relying on Rafiq Masih. The 4 judgments which I have just handed over for this honorable court.
No, on the other day you have referred it. Rafiq Masih's case.
My lord, Rafiq Masih, all right, my lord. Rafiq Masih, I was just referring to because of one paragraph, my lord. I have Rafiq Masih, I will not suppress. But Rafiq Masih, to the extent that the last page of Rafiq Masih, my lord, that recovery from retired employee is harsh. That was also an observation made in Rafiq Masih. My lord, in a judgment, there are several observations. Big judgment like Rafiq Masih, for example. So I was relying on only that point, that recovery from a retired employee is constituted to be harsh as per Rafiq Masih. Rafiq Masih has other observations. I have the judgment, my lord. If I can hand it over to my lord.
No,
I have
not
flagged my lord knows it. My lord, may I kindly refer to my second judgment, my lord, Sushil Kumar Borua versus State of Assam. My lord has it. I flagged the relevant para also, my lord, 11 and 15. Same thing, my lord. After 4 years, it cannot be done. And in this case, my lord, the Krishna Pandey case was also referred. Law is very clear, my lord. Within 4 years, you conduct the inquiry, you do the recovery if need be. If I am found guilty, very well. But my lord, after the period has passed, how can it be done, my lord? Show cause has to be given, my lord. There is a procedure of law. If this way it is done, then anybody can be targeted, my lord, tomorrow. Tomorrow, after 20 years, suppose I work in a work as a government employee.
No one is targeted except you.
My lord, the authorities know it better, my lord. Authorities know it better, my lord. And my lord, may I hand over one more judgment, my lord? It says that one cannot take benefit of their own wrong, my lord. One cannot take benefit of their own wrong. The wrong has been considered by them, my lord, in the instance. They should have conducted the inquiry in the appropriate time. If there is any discrepancy, which they are alleging, you should have given me a show cause notice, told me to appear. I would have duly appeared, and then maybe the recovery could have been done. Today, after
They have not yet recovered the amount. They have only given you the notice.
they have given me the notice from 1/6/2020, 1/6/2024, they could have done the procedure. But now we are in 25, my lord. Now how can they do it? As per law, they cannot do it, my lord. They are saying that I have stayed for 2 years. They are saying this. They are saying, I understand, my lord. There can be many contentions by the respondent authorities, but is it permissible under law? That is the bone of contention in this case. Moreover, my lord, it is not like I had not replied to the said notice. That 1/6/2020 notice on 17/7/2020, I had given a reply. Maybe that last line is there. My lord is absolutely correct. That I am ready to and all that portion. But I had intimated them that my admit card's date of birth is correct. When they knew about it, when it was in their knowledge, they could have given me a show cause notice, could have called me for an inquiry. That the proper procedure, my lord. There could have been an officer to conduct the inquiry. Why didn't they do it?
But why you remain silent?
No, my lord, I have not remained.
The date of passing of your SSLC examination.
My lord, that is the problem, my lord, which I see today.
You have already noticed that there is discrepancy in the admit card and your SSLC pass certificate.
Yes, ma'am.
You waited till your retirement.
With due respect, my lord, nowadays, my lord, when I had appeared for my examinations in 2012, our date of birth, for example, mine is 19/11/96. It is clearly stated in the mark sheets. Earlier, it used to be like this. Then people used to, what I understood, my lord, from the whole sequence, my lord. These kind of discrepancies would arise. People would work. My lord, they didn't get one. They did not want to go into that kind of, my lord, tanglement, my lord. My lord, they just wanted to work and pass it off. That is there, my lord. I should have approached the authorities earlier, but I did so, my lord. 2 years before my retirement, my lord. It's not like just one day prior to my retirement, I told them. 2 years period, my lord. I did, my lord. They could have taken action, my lord. They could have acted upon it.
Therefore, they have already given notice to you.
Notice they have
And you
given,
have
my
given
lord.
your undertaking.
My lord, they have given notice.
Now you are finding fault with them.
No, my lord, notice they have given mine. To this I replied. It's not like I kept mum.
No, merely because you have replied, it will not do. Anyway.
My lord, may I kindly refer to the other two judgments, my lord? My lord would kindly have, my lord, Daksha Prasad Das, my lord. Daksha Prasad Das and Bhanwari Singh Rajput, my lord. I have flagged the relevant portions, my lord. They, my lord, categorically state that in such kind of discrepancy regarding the entry of birth, my lord, or any such discrepancy, my lord, minimum show cause has to be given, my lord. Opportunity has to be given to the person while in service. And even after retirement, my lord, that 4 years period, my lord.
No, this judgment will not help you because they have given notice to you before acting upon.
No, my lord.
And they have not yet acted upon your case.
My lord, mere notice will not apply. My lord, what constitutes natural justice to my, sorry, my lord, sorry.
Then
what constitutes natural
they have
justice?
already given notice to you.
Notice given.
You have replied to it.
Notice
then
given.
does it mean that they have not complied with the principle of natural justice?
No, my lord. To my humble
what do you mean by it?
My lord, to my humble understanding, I may be wrong, my lord. But what constitutes natural justice is in these kind of cases, my lord, at least with regarding these kind of cases, which require some kind of deliberation. Mere giving one notice, then receiving a reply, does not put a full stop to the case.
Then
My lord,
what the authority has to do?
they should have conducted an inquiry then and there, my lord, or at least within those 4 years. They should have called me. No, they should have called me, my lord.
Okay.
That was not done in the case, my lord.
Heard Mr. Sharma, learned counsel for the petitioner. Mr. Sharma, you have any reply?
Only one thing I would like to submit to office. My learned friend is time and again telling that my date of birth in the admit card is correct and the date of birth mentioned in the HSLC pass certificate is incorrect. Whether my learned friend has approached the concerned SEBA authority at the prescribed period of time for correction of the date of birth? No.
No, my lord, because they are my
Therefore-
employers. They are my employers. I have responded to my employers.
This is not.
SEBA is not my employer, my lord. The district elementary education office, I have replied to them. That is why, my lord. And they gave me a notice. That is why I replied to them. They are accountable, my lord.
We have already put him under notice.
My lord, I have also replied to the notice. My lord, if someone gives me a notice, I'll have to reply to them, right, my lord? My lord, may kindly have page 66 for a moment, my lord.
Yes.
To this query which is raised, my lord. I don't have further submissions, only this submission, my lord, which was raised by my senior just now.
Yes.
This notice, my lord, which is in question, this was sent from the Block Elementary Education Officer Golaghat. At page 69, I had replied to them, my lord. Now, where does SEBA come from, my lord? They should have taken cognizance of the matter, since they had sent me the notice. SEBA, my lord, how can I, after so many years, my lord? They should have taken cognizance, they should have they should have sent a letter then. The letters which were sent between the between the Education Department and SEBA in the instant case was done after 22. After my retirement, they could have conducted it before 31/7/22 while I was in service.
Okay. Heard Mr. P.R. Sharma, learned counsel for the petitioner, and Mr. P.N. Sharma, learned standing counsel for the respondent number 1, 2, 4, 5, and 6. Mr. D. Bhattacharya, learned standing counsel for the respondent number 3. And Mr. D.K. Roy, learned standing counsel for the respondent number 9. And who is for Mr. Soliha for respondent number 10. You were representing Treasury officer also. 11. Argument concluded. Judgment reserved.
I am deeply obliged, man.
Standing item 43 for motion.
Yes.
Lordship, kindly have a look at page 120 of my additional affidavit. Prayer in the title suit.
Yes.
Oh, Lordship, I pass a decree declaring the right title and interest as well as confirmation of possession over the suit land in favor of the plaintiff. Pass a decree cancelling the illegal and unjust mutation dated 16/12/94 done by the principal defendant. Pass a decree for cancelling the Rayati and Adihar note in respect of 1971 suit patta. Issue precept to circle officer Hujai after cancelling the mutation for necessary action. Pass a decree for the entire cost of the suit. So it is a basically suit for a declaration of right title and interaction confirmation of possession. But our case, Lordship, in this suit, that we are the legal heir of one Manohar Ali, and it is our inherited land. We are in possession. Case of the plaintiff is that one Shurujali purchased the land from our predecessor, but Shurujali lordship the pleaded in the plaint, it is pleaded that he left India long back, and from Shurujali they have purchased the land. It is our case that at no point of time Manohar Ali sold the land to anyone, and we are in all along possession lordship. At this stage, lordship, my prayer is notice may go and the status quo may maintain. Otherwise, lordship, we have no objection.
There any, oh, okay. Execution cases pending now.
Lordship.
Where is the appeal order?
Lordship. That is lordship, kindly come to page 74.
70?
74. It starts from page 74, Annexure 7. And finding of the learned court. Lordship, kindly come to page 77.
The question is whether the executing court can go behind the decree.
No, Lordship. This is my submission also, Lordship. A suit for confirmation of possession, that cannot be for recovery of first possession. That is my humble submission before your Lordship. Now they are going to recover the possession where we are possessing the land. That cannot be, Lordship.
Whether any subsequent development took place after filing of the suit.
Subsequent development.
Whether any subsequent development took place after filing of the suit. Title suit.
No, Lordship.
On what basis he was submitting that they are going to recover the possession now? Mr. Mozumdar?
Lordship, in the Patta number 104, we are all along in possession, Lordship. At no point of time they are in possession, and it is their pleaded case that they are in possession. In the whole area of disputed suit land, Lordship. But we are in possession in Patta number 104.
104? Decree was granted in respect of which Patra?
Patta number 61.
Patra number?
61.
Where is the judgment?
Judgment, Lordship.
It starts from page number 26.
No, Lordship, it is initial Lordship judgment. Lordship, kindly come to page 49.
49.
Lordship. Initially, it was decreed earlier, Lordship, and thereafter appeal preferred. Appellate court remand back the matter, and a fresh decision was taken by the learned trial court.
No, you saw me the judgment.
Lordship, page 49, Annexure 3.
49.
Lordship. And Lordship,
And
Lordship, finding of the court in regarding the issue number 1 and 7, that is the main issue in this case, Lordship. Kindly have a look at page 53, 54.
You come to the order.
Page 59, Lordship.
59.
Lordship. In the result, the plaintiff's suit is decreed on contest with court. It is decreed that the plaintiff has got the right title over 27 bighas 3 kata suit land given in the schedule of the pledge. Suit is further decreed that the mutation obtained by the defendant on 16 to 94 is illegal, and the Rayati Kotian is also illegal. It is not my case, Rayati Kotian. It is not our case, Lordship. Issue precept accordingly.
No, this you come to the schedule of the plaintiff, page number 122. There it is stated that land measuring 27 bigha 3 kata covered by tag number 132 old 104 new, pattern number 62/49 old 61 new of Pasim Bogoriguri Kisam under Moza Zugizan. And the decree was granted in respect of this serial land.
Lordship.
So 104 is the DAG number, not patta number.
Yeah, DAG number, Lordship, it is, and patta number it is 61. 61.
Stroke 49 old and 61 is new.
Lordship.
Let notice to this system. Term order will be considered on next step. Let the other side appear.
Lordship.
Mr. L.R. Mazumdar, learned. Counsel for the petitioner. In this petition under Article 227 of the Constitution of India, the petitioner has challenged the correctness or under section 150 of the Code of Civil Procedure. The petitioner has challenged the order dated 28/5/2025 passed by the learned civil judge in Division Nagaon. It is to be noted here that by the impugn order dated so and so, the learned civil judge in Division Nagaon has dismissed the Miche case number 208 of 2024, which was registered on the strength of a petition number 109 of 2024, filed by the petitioner herein in connection with title execution case number 4 of 2023, arising out of PS number 83 of 96, filed by the petitioner. Stroke defendants, stroke judgment debtors, trying for dismissal of the execution petition filed by the opposite parties, stroke plaintiff, stroke decree holder herein. No, decree holder. Where is the petition, the documents plus on record, and also where is the impugn order dated 28/5/2025, and also, okay. Let notice be issued to the respondents, returnable in 4 weeks. Step be taken by registered post with KD and also by usual process. Interim period of the petitioner will be considered on next date on appearance of the other side. List of the purpose.
Item 14,
Obliged.
alternate.
In this case, my lord, want to file an additional affidavit. Certain new facts has come up, my lord, but the petitioner along with other persons were copied that a fact-finding mission was put into the pen in the fact-finding mission. It was found that this person along with other 37 persons have never faced an interview. They were all running a court on an ad hoc basis, movement expense. So ultimately, after a government order, he was regularized with a date which is after 2005, my lord. That's why the new pension scheme is entitled, not the old pension scheme. I'll put it on affidavit, that particular document, how the inquiry was conducted. The inquiry report was there, and subsequently that he was given the regularization after the 2005.
In the meantime, I may be allowed to furnish a copy of my service book and attendant register, lordship, for establishing my regularization and continuity, lordship.
File an additional affidavit.
By way of additional. Obliged. After this filing, lordship, I will.
Okay.
Obliged, lordship.
Mr. S. Salukar, learned counsel for the petition, and also Sir S. Bora, learned counsel for the document number 2. Sir R. Barputari, learned standing counsel for the respondent number 3. And Mr. Sarma for respondent number 1. But Mr. Bora, learned standing counsel for the respondent number 2 submits that he may be granted some time to bring on record one inquiry report. Inquiry report. Inquiry report. Carries allowed or dismissal is the matter. When? After application. Immediately after reopening of the application.
As part of, lordship. As part of.
Okay. The dismissal in the part.
Obliged, lordship.
15, ordered matter.
Here I may be allowed some time to bring on record some documents, lordship. So I will file a short affidavit, lordship. Some time may be granted.
My lord, in respect, my lord, I have no objection, but one thing I want to show my lordship, that was an order of my lord honorable court on 6/1/2025. Well, whatever they brings, but that should be as per that consonance, my lord. This is, kindly have a look at the order, the 6/1, my lord. This passed by 6/1. It is passed by honorable justice, my lord, you can have, my lord. there was an instruction to file their affidavit in that consonance, my lord. So they have to bring these things. I don't know, my lord, why they are taking so much time to filing these things, and earlier occasion also they abruptly failed to file the affidavit. Ultimately, one caution was given, then it came with another affidavit. Now we are going to file another affidavit. So that should be as per that consonance, my lord. I have no objection. As per that direction, they have to file the affidavit. Because there is a specific direction. Bring anything, any record regarding the strict follow of this, my lord, criteria in 92 regarding the UGC. Till today, they have not complied that direction.
So, Upamanyu, on the other day, you have been asked to obtain instruction in respect of annexure number 11.
Yes, my lord. Annex 11. Application of the UGC norms in phase manner in the state in which year that was there.
I'll get my to that point.
What reply will you give? This is your notification.
Yes, my lord. This is their director, this secretary has issued the communication to the minister PS.
I'll be getting some instruction by today, Lordship.
Pardon?
By today, Lordship, I'll be getting some instruction. So let me file Lordship a short affidavit. Sometime, Lordship. Not too much time.
Heard Mr. P. Mohanto, Lord and Counsel for the petition. Sir T. U. Upamanyu, Lord and Standing Counsel for the Higher Education Department. Mr.
Vijay Das, on behalf of Dr. P. Agarwal.
On behalf of Ms. T. Agarwal, Lord and Standing
UGC.
Counsel for the UGC. Mr. Upamanyu, Lord and Counsel for the Learned Standing Counsel for the Higher Education Department submits that though he was directed to obtain inspection in respect of annexure number 11 at page number 42 of the petition, he tries for granting him some time to file a short affidavit in respect of the aforementioned annexure. There is accordingly allowed presidential legislature when before vacation.
My lord, short date maybe, my lord, is a long time, my lord, I am sorry. So that should come within, my lord, Friday they have to file, and Monday that may be listed, my lord, or a Tuesday, my lord.
Monday, 23rd.
By Monday, Lordship. I'll
My lord,
file,
one
Lordship.
more,
Come on
my lord.
Tuesday or Wednesday.
My lord, one more prayer, my lord, this affidavit there, whatever you were going to file in regarding to that, my lord, the annexure 11. That should also, my lord, be in consonance to the, my lord, order that was reflected on 6-1. Because that is the very vital things that Lordship has earlier observed, that what is the criteria in following in that particular area, particular year. That should be reflected, my lord. That should come along with this affidavit. Because case is that, my lord, in 92, there was no such, my lord, criteria, whatever they are now saying, in imposing in my appointment letter.
As per 92 criteria, Lordship, I'll file, Lordship, as per.
What was the strict criteria? Whether they are following the strictly that for criteria. That is a very emphasizing particular that word. Because in the same college, same advertisement, 3 persons are appointed. 2 was not given any such type of conditions. In case of me, my lord, that was only imposed. And in other respect also in all the colleges, at that time, relevant time appointed, no such terms and condition was imposed. So this is my vital, my lord, stand in my petition also. And if being satisfied, lordship also passed by order 6-1 that their affidavit as per this, my lord, direction, that should be as per the consonants of that order. So that was not filed as per whatever affidavit they have filed, no whisper about these things. Totally, it is totally blank. So if they want to come with another affidavit, then that should be also be reflected. My humble prayer, lordship.
The Learned Standing Council for the Higher Education Department shall also comply with the order of this court dated 6/1/2025, indicating in the affidavit that the recruitment that were made across the state in various deficit granting 8 colleges were made strictly in accordance with the norms laid down by the UGC by its notification dated 1991. List on
Monday,
By Monday, Lord, I'll file on Wednesday, 25th.
25th, Wednesday.
Item 46.
For the respondents. They challenged the order dated 21/2/21/12/24 at page 105.
My lord, my senior is currently at another plot. Please being time being passed over.
For the day?
Yes.
For the day. On the prayer being made by Mr.
Rakesh Moore.
Rakesh Moore. Learned Council. Your name?
Rakesh Kolita.
Rakesh Kolita, Learned Council appearing on behalf of Mr. R.K. Moore. Learned Conducting Council for the petition. Rise for adjournment of the matter for the day. The prayer having not been objected on by Mr. G. Jalan.
Can it be on next Monday, man?
For the respondent number 1 and 2.
1 and 2 both.
Hello. List on the vacation or
Before vacation, because next date is, after vacation it can be, but if it's fixed date is fixed, next date is 23/7. If it can come up on 15th or 14th May. 14th or 15th today. Much obliged.
Item for hearing under order 41. Item 16.
Before arguing on the point of admission, my lord, we have filed a petition for amending the memo of appeal, my lord.
No, you have done it.
No, this is separate. And this is
This
separate.
is separate.
Yes, my lord.
Okay.
That was the same mistake, my lord, we have filed. Earlier it was allowed. And it was rather appeal 4 and it is 5, my lord.
Okay. Art Mr.
Niket.
Learned Council for the appellant, and Mr. So for respondent number? Respondent. Mr. Das, Learned Council for the appellant submits that he may be granted some time to file amended memo of appeal as some mistake has been committed while filing this appeal. There is accordingly allowed recess of the matter. Why? After vacation.
But tomorrow we will file it.
Tomorrow.
File it, my lord. Fix a date for listing, my lord.
27.
27.
By tomorrow they'll
Not-
file and 27 this month.
Not my lord. Can it be on 26? 26 or 25 any date? Not 27. 26 or 5.
Okay.
Obligement.
Number 17.
Along with the other RA Appeal 4 of 2025.
That has already been fixed.
Yes. No. Pick.
Not that fixed.
No, that is. Along with my lord, that is why my lord.
As a decade of learned counsel for the petitioner further submitted another RERA appeal, being RERA appeal number
4 of 2025.
4 of 2025 is also pending between the same party.
Same party.
And accordingly, he applies for listing. For taking this matter, there is accordingly.
Obligement.
May it please your lordship.
Yes.
The dispute between two brothers. And the suit was initially filed in the year 2014, my lord. Suit had around at least 8 prayers. Now, amongst the prayers, my lord, there was a decree prayed for partition of the suit. I mean, suit properties. But during cross-examination, it reveals from the cross-examination, my lord, that the plaintiff, he admitted that the properties were partitioned amongst the brothers by the local people, the uncles and everything. And they are accordingly possessing the respective shares. But one question, my lord, there was a specific pleading as well as evidence led to the effect that the defendants with his fellow men were trying to trespass into his land. Now, so far as that pleading is concerned, my lord, there was no denial to that effect. But there is no finding rendered, my lord. The learned trial court held the suit to be not maintainable. And on that basis, the suit was dismissed, my lord. The learned first appellate court, my lord, reversed the finding on maintainability, held the suit to be maintainable, but held that since the respective parties are already in possession of the respective shares, there is nothing left to be decided, and the suit properties cannot be partitioned. But this aspect of the matter, that was left unanswered, my lord. My specific case, if your lordship kindly turns to para 11 of the plaint, which is at page 17 of the memo of appeal.
Yes.
11, my lord. That the defendant has no any manner of right, title and interest upon the land of the A1 schedule land within the schedule A land, B1 schedule within the B schedule land, and F1 schedule within the F schedule land. But the defendant and his fellow men on 5/11/2014 entered into parts of the land of the plaintiff, that is A1 schedule land within A, B1 within B, and F1 within F, and started to erect wall without any information to the plaintiff and without reserving the share of the land of the plaintiff within the so and so schedules. The plaintiff vehemently restrained the defendant to erect wall haphazardly, but the defendant did pay no heed against the request of the plaintiff. Rather, the defendant threatened the plaintiff with dire consequences not to enter. Now, the reply to this pleading is at page 30, madam. Para 18 of the written statement. That was paragraph 18 of the plaint, para 18 of the written statement. The averment meant in paragraph 11 of the plaint is denied by the defendant. There is no specific denial. And the prayer with regard to this is, my lord, prayer number 7, my lord. I had prayed for a permanent injunction restraining this is meant to enter into my land. That prayer is at page 22. Romans 7.
So the first appellate court has decreed the suit.
No, my lord, dismiss this.
First appellate court.
Both. The concurrent finding.
Okay.
The first,
No, you have submitted that reverse the finding.
Reverse the finding on maintainability.
Okay.
held the suit to be maintainable, but dismissed the suit on the ground that the parties are already in possession of their respective shares and nothing is left to be decided. But there was a specific pleading, and most importantly, my lord, the defendants did not even lead evidence. My limited challenge is that there was an encroachment in my land. They have constructed the wall. You have not denied, you have not led evidence.
Substantial question of law you have suggested.
I have suggested, my lord. Four, I'm now pressing for the substantial question number 4, my lord. Because I've seen the records, my lord. There was a partition case and filed by both, my lord. And so that the suit was partition. I have also examined the cross-examination where the plaintiff admits that yes, it was partition. But there is a specific, even in the evidence, he states that they had tried to encroach upon my land. And there is no denial in that written statement, and no evidence was led by the defendant. That finding that the evidence was not led, my lord. At page 86, my lord, the court says, First Appellate Court, para 14 in the middle portion. Defendants have not adduced any evidence, oral or document.
Paragraph number?
Para 14 of the appellate judgment at page 86. The court, after hearing both sides, perused the case record of so-and-so along with the documentary evidence as well as oral evidence. Defendants have not adduced any evidence, oral or document. Even in that view of the matter, the denial in paragraph 18 of the WS has not been established by leading evidence. My limited flair now, my lord, so far as my allegation of encroaching upon my land, that no finding is rendered even though there is no denial. If your lordship turns to page 88, also para 19, this is where the finding of maintainability is reversed. The learned appellate court holds, my lord, the defendant in his written statement has admitted most of the averments of the plaintiff and raised no probable defense or any averment that the suit lands are not mutated in his name or in the name of plaintiff. What defendant states is the suit lands are already partitioned between the parties, white partition dated so and so and so and so. Defendant has also not adduced evidence, oral or documented, to prove non-maintainability of the suit, and therefore this court is of the view that the suit is maintainable. Issue number B is therefore interfered with and decided in favor of the appellant. This is where the maintainability part is reversed.
No, going by this substantial question of law, at point number 4,
my lord,
whether it can be said that it is a question of law, whether what question of law is involved herein?
Because when the defendant does not deny my specific claim in the plaint, then that has to be admitted. A thing which is admitted need not be proved, my lord. Because lordship knows in a WS, there should be specific denial. Merely saying that it is denied will not do. He has to deny that it has not been encroached upon.
No, though there is no detailed description in that paragraph.
That lordship is correct.
He denied it.
Because out of I have gone through the entire thing, my lord. Out of the schedules also, the plaintiff was claiming right title interest over the schedule C land. And in the written statement as well as, in the cross, it has come up that schedule C land was purchased by him Why that schedule C land was included, that also is difficult to comprehend at this stage.
It's all right, but the thing is that there is concurrent finding of fact.
Yes, madam.
Being the second appellate court, this court cannot go into the facts unless the plea of perversity is taken.
No, plea of perversity is not there in the sense that, my lord, there is no finding rendered. As regards the encroachment, in spite of there being a specific plea in the plaint, in the evidence, no denial, no finding is
No,
rendered.
that's all right. Then you have to suggest this question in other way.
Then this question of law would be that whether in view of the admissions, the learned courts below were justified in not rendering a finding. The Lordship will,
all right.
I'll try to frame it differently, my lord. Lordship will take it up
Suggest it, we will see.
on Friday,
Let
my
it be fixed on another day.
on Friday.
Friday. Heard Mr. Tackle or network reporter? Appellant. It's on Friday for further consideration.
My lord.
May it please, your Lordship.
Yes.
Lordship, order dated 9/6, Lordship. Till date, the petitioner has not received any
salary. Mr.
Lordship.
Sharma, you received
Yes,
any instruction?
This is the salary statement produced by the inspector of school, and it is submitted to the treasury office, my lord. Now it is pending on the treasury office. Yeah, my lord. For the month of March,
March, April, May.
March, April, May. March. April.
Current salary.
Yes, ma'am. And regarding the arrears and the salary, my lord, it is process under process, my lord.
But on the other day, you have submitted
Yes.
that the salary has already been paid, arrear salary.
No, my lord. As per my instruction, my lord, 8/6/2025. Here, my lord, it is clearly written as now the matter of payment of arrear salary 1/1/2021 to Umar Ali Sheikh is under process in the Inspectorate of School, Dhuburi District Circle. And this letter has already been produced before this Honorable Court, my lord, on last occasion.
But
So it should
there
be
is a recording.
clarified that it is arrear salary is still under process, my lord. And I have already talked to Inspector of School, and Inspector of School also told me that it is under process, my lord.
No, under process already, but how long you will take to disperse the salary? And regarding this current
Current salary, my lord, already statement has submitted to the Treasury Office, my lord.
statement or bill?
It is, yes, it is pending on demand.
Since when you have submitted?
Article 6/2025.
13/6.
Yes.
Oh, Mr. Sharma, you obtain an instruction of when this current salary for the month of April and May will be credited in his account.
March, April, May.
March, April, May.
Yes.
Can you obtain instruction after some time?
After some, my lord, it is pending on Treasury office. So,
No,
my
that's all
lord,
right. Treasury office, you
and
obtain
I
it.
have no touch with the Treasury office. I have to ask an inspector of school, then he will make communication.
Let him know. Let the inspector inquire from the Treasury office and inform you. After half an hour, we will take it up.
Item 20.
Yeah, please, Lordship. My lord, in this case, my lord, the MSc appeal, my lord, was filed where there was delay of 68 days. Delay condition petition was there, my lord, which was dismissed, my lord, for non-prosecution. My lord, petitioner appellant filed thereafter, my lord, restoration petition 73, my lord, miss case 73, 2023, my lord. My lord, page, can you see, my lord, page 12, 11%, 13, my lord. Page 13.
This miss case is for restoration.
Restoration, yes, my lord. But in restoration, there is also a delay of 61 days, my lord. So, my lord, condition is delay petition is there, my lord, 2830, my lord.
Petition number
2830.
2830.
ISC. The reason is, my lord, at page 3, page 7, my lord, paragraph 3, my lord. The reason explained, my lord, the engaged counsel, my lord, at that relevant point of time, my lord, his old ailing uncle, my lord, who died at the age of 105 years, my lord. So there was some delay in filing the restoration petition.
Whether any counsel appears for the other side?
No, my lord.
No.
Receive of appeal.
Why it is I number 3574 was filed?
My lord, for continuance of delay of 68 days in filing MSc appeal, my lord.
Let notice go at this. Pardon me, sir.
Arrest Chauhan, my lord.
Learn a counsel for the applicant. This interlocutory application under Order 41, Rule 3A. Read with Section 5 of the Limitation Act is preferred for condonation of delay of 61 days in filing interlocutory application in by civil number. What is the number? Civil number? It is
73 million. My lord.
$73. Interlocutory application or miss case?
Miscase, my lord. At the time it was miscase, my lord.
Miss case.
Miscase 73/23, my lord.
But you have mentioned it as interlocutory application. It connected miss case for restoration of the MSc appeal number 886 of 2018. Issue notice to the respondent or the opposite party. Study taken by research post with 18 of the vehicle process within a week from today. Justice service is also permitted. If after effecting service upon the respondent, opposite parties, the learned counsel for the applicant shall file an affidavit. This chapter for it.
Obliged.
21.
My lord, I will draw your lordship's attention to order dated 11/6/2025. Your lordship may see the third paragraph. Accordingly, it is provided that so-and-so shall take necessary steps for effecting service upon the respondent by substituted mode by paper publication in the English Daily Assam Tribune widely circulated in that area. My lord, there one line your lordship dictated by fixing the date of appearance on the sole respondent on such and such. That has been missing, my lord.
You have filed IA for this purpose.
No, my lord, it's just by order it has come. So,
By
my lord, this is the line to be added only.
Heard Mr. S. Dotto, learned senior counsel, assisted by Mr. S. Dotto, learned counsel for the counsel. Mr. Dotto, referring to the order dated 11/6/2025, submits that though the petitioner was permitted for effecting service upon the respondent by substituted mode by paper publication in the English Daily, the Assam Tribune widely circulated in that area, yet no date has been fixed. And accordingly, Mr. Dotto submits that a date has to be fixed on which
Appearance of the sole respondent. Any date before, my lord, is fixed on
that
28th.
date has to be mentioned in the notice in the paper.
Yes, yes, in the paper, it would have to be reflected, my lord, on which date they are required to appear. Your lordship has fixed 28/7/2025.
28/7.
Before that, 4-5 days ahead, your lordship can fix a date. Maybe on 25/7.
25/7.
No, 25. 25 is, yes, 25/7. Huh? Wait, second. No.
Accordingly, it is provided that the date of appearance of the respondent in the notice to be published in the Assam Tribune shall be fixed on
25/7.
25/7, and thereafter the rest shall list the matter on.
We are required to file an affidavit to that respect.
28/7.
Yeah, 28/7 it will come up.
The learned counsel for the petitioner shall file an affidavit before this court to that effect, enclosing the paper, relevant paper.
Much obliged.
22.
Transfer this one, lordship. This one is the wife, lord.
This IA is for what purpose?
Transfer the one case is pending, lordship. Guardianship case is pending at Gualpara. Petitioner is a assistant.
IA, we have filed the IA.
Okay. IA is for what purpose?
My lord, this IA, your lordship will find the terms of agreement that has been flouted by them. My lord, I'll just take your lordships to. My lord, we have filed an objection petition, your lordship will find in the record.
Page 25.
Your Lordship may see page 53, that is the joint affidavit filed by both the parties.
Yes.
That the petitioner number 1 and 2 filed this affidavit for compromise, the above mentioned case to mutually divorce each other on the following terms and conditions. That the child, Ranjan Pratim Chakravarti, will stay with his father for 10 days during summer holidays each year. That the child will stay with his father for 10 days after each annual examination. That the father will visit his child every first and second Sunday. If first party fails to allow them, then father will visit
Mr.
his son.
Tutor,
Yes.
Mr. Tutor, this petition is filed, this is a transfer petition.
My lord.
Whether we can consider violation of the terms
My lord,
of settlement in this petition.
in fact, my lord, I am not asking for that. Your lordship, so far transfer petition is concerned, we shall concede to the prayer made by them. Your lordship may kindly see the prayer made. To that effect, my lord, your lordship kindly see paragraph 10 of the transfer petition. Your lordship may kindly come to page 8. Therefore, for the ends of justice, second para. Therefore, for the ends of justice, the case may be transferred from learned additional district judge Dwalpada to the principal judge family court, Kamrup Metro at Guwahati, or some other member they have said. So far, this prayer is concerned, principal judge family court, Kamrup Metro at Guwahati, we are agreeable, my lord.
You are agreeable?
Agreeable, my lord. To that extent, my lord, this transfer petition may be allowed. But then your lordship can see their conduct. My lord, there is an agreement. They have,
In transfer petition, how can we adjudicate that issue?
my lord, a direction may be given so that they only to comply with that. Because
No. In transfer petition, I don't think that it's transferred.
other this person, my lord, he is not in for last 6 months. No? For last 6 months, my lord, he has not been given a chance to see his son. So that is my limited prayer, because this is the term of agreement. Both sides we have agreed. So my lord, even the executing court, my lord, we filed a petition there. Executing court called both the parties. And the learned judge himself talked to the child also. Now, after talking all of them, we passed that order that this observation will have to be maintained. my lord.
You go and raise the issue before the trial court for the case is done. But today we are disposing of this transfer petition.
That of course your lordship can do it. But my lord, your lordship can give a direction to the trial court so that.
Okay. Heard Mr. L. Gogoi, learned counsel for the petitioner, and Mr. S. Datta, learned senior counsel assisted by Ms. M. Soduri, learned counsel. This application under section 24 of the Code of Civil Procedure is preferred by the applicant. Preferred by the petitioner. Transfer of Miss Guardianship case number 03 of 2019 pending before the Court of Learned Additional District Judge Dwalpada to the Court of Principal Judge Family Court Kamrup at Guwahati or Kamrup Rural, or to the Court of
Nalbari.
or to the in Nalbari also family court is there.
No, Nalbari district.
Kamrup Metro will be better for me because the distance will be 124 kilometers.
Present petitioner staying at Nalbari there. I'm given 3 options.
He has given 3 options, my lord. I can choose out of the 3 any. So therefore, my lord, so far, Principal Judge Family Court Kamrup Kamrup Metro will be convenient for me.
Gwalpara is the too much distance, 150 kilometers
from Gwalpara.
From Gwalpara?
From Nalbari to Gwalpara. Therefore, I'm paying for nearest district.
Petitioner is residing at Gwalpara,
No,
no, Nalbari.
Nalbari.
The respondent is residing at Gwalpara.
Gwalpara.
For me, if it is Nalbari, 181 kilometers.
Yes.
If it is Guwahati, 124 kilometers.
Then Kamrup rural?
Rural will be much more than that.
Why?
Family
Because-
court should be better.
Rural would be better.
The metro will be, I'm told metro will be shorter, man. Distance will be lesser.
Metro is here.
Yes, here.
And go. Immediately after crossing the river Brahmaputra, you will reach. Coming down.
Family method transfer method family court
Pardon?
Family court Guwahati.
Family court?
Guwahati.
She resides here. But they also want that, then both the
I have
side.
no objection.
I'm also.
Okay, then all right. Or to the Nalbari district.
Or
To the
Nalbari.
Nalbari district. No, it is your pair.
Yes.
Mr. Gogoi, learned counsel for the petitioner, submits that the respondent herein has instituted the misguardianship case number 3 of 2019 before the Court of Additional District Judge at Gwalpara. But the petitioner herein is presently residing at Guwahati. He is residing at Guwahati now.
Nalbari.
Nalbari. And it is difficult on her part to contest the aforementioned proceeding before the Court of Learned Additional District Judge at Gwalpara from Nalbari. And as such, Mr. Gogoi submits that the proceeding pending before the Court of Learned Additional District Judge Gwalpara may be transferred to the family court, Principal Judge Family Court at Guwahati. Mr. S. Dotto, learned senior counsel for the respondent, submits that he has no objection in the event of transferring the proceeding of Miss Guardianship case number 3 of 2019 to the Court of Learned Principal Judge Family Court at Guwahati. We are taking note of the submission of learned counsel for both the parties. The Miss Guardianship case number 3 of 2019 pending before the Court of Learned Principal Judge Learned Additional District Judge Gwalpara stands transferred to the Court of Learned Principal Judge Family Court number 1 Guwahati. But the petitioner shall obtain a certified copy of this order and place the same before the Court of Learned Additional District Judge at Gwalpara, and on the receipt of the same, the Learned Additional District Judge Gwalpara shall take necessary step for transmitting the record to the Court of Learned Principal Judge Family Court number 1, Kamrup M. Guwahati. In terms of this transfer petition instance, dispose of. I heard Mr. S. Dotto, learned counsel for the petitioner, and I applicant, and also heard Mr. L. Gogoi, learned counsel for the respondent, opposite party. This interlocutory application is referred by the applicant for compliance of the order dated 15/5/2023 in FC civil case number 49 of 2019. And also the order dated 24/10/2024 in title execution case number 8 of 2023. Passed by the learned principal judge family court number 2 Kamrup and Guwahati. So how many cases are there?
Only, my lord, the guardianship act, the cases pending in that respect only. Others are all over. Maintaining.
No, this execution case is pending at Guwahati.
That is
Close, losses. Close.
That's closed.
Closed. Since the transfer petition number 113 of 2023 has already been disposed of by transferring the case guardianship case number so and so to the Court of Learned Principal Judge Family Court number 1 Kamrup and Guwahati. This interlocutory application stands closed, granting liberty to the applicant to raise this issue before the Learned Principal Judge Family Court Kamrup and Guwahati.
Yes, much
obliged.
23.
Before coming to that, I prefer short accommodation for today, lots. Having such a difficulty, lots. Any fix a week. Before
I is for what purpose?
I for application of section 151 for recalling the stay order. Order dated 13/11/24, modifying the stay, vacating the stay order. As passed by this honorable.
Any objection?
Appeal admitted and my lord, the stay is granted under order 41 rule 5, my lord. And already record is, my lord,
Record has been received.
received. Then case may be heard, my lord, that we, my lord, myself and my learned friend M. Soronia, my lord, we subsequently, my lord, entered appearance, my lord, we filed Okalatnama. Okalatnama tag, but our name has not been shown, my lord. We just morning came to know this case is listed. So late deal, next date, our name may be shown, my lord. C. Goswami and M. Soronia. And my lord, case may be heard. And as there.
This I is for what purpose?
I is for under section 151 for recalling.
For
modifying
vacating
the
stay, my lord.
order dated 13/11/24.
If the matter is ready for hearing, then we can hear the matter.
Yes, ma'am.
Along with it. Along with it, we can be here.
Not necessary, my lord. It's the main case is heard, my lord, that stay vacate petition is redundant.
But this petition, interlocutory application is filed by you.
Yes, I'm the applicant.
Part Mr. Bhaktiar, learned counsel for the applicant, C. Goswami, learned counsel for the opposite party.
Opposite party.
Mr. Bhaktiar submits that he may be granted some accommodation for today. There is accordingly allowed. This is a list. It's matter along with RSA.
Fixed. Any date may be fixed, Lord.
Just after vacation, my lord, main case may heard.
RSA number 187 of 2024, not accept.
And my lord, the IA petition, my lord, that IA petition for praying for stay, that was petition was allowed, but that it was still for returnable date.
Till
So,
returnable.
my lord, maybe continue because
very much.
there is ambiguity. That's why.
List the matter after vacation. After vacation.
Yes, my lord.
16th of
17 July.
Much obliged.
25.
Please, Lordship. My lord, the respondent is claiming filed one impleadment petition. They have not furnished to me, and there is some defective also. So for the timing, my lord, I'm calling is
26.
Please, Lordship. My lord, here I-1930 we have filed, my lord, regarding withdrawal of the 50% award, my lord. Lordship, order at page 11, paragraph 3 and 4.
So the amount was deposited before the arrest date?
Yes, my lord, 15 May deposited.
We have deposited lordship, it may be withdrawn, subject to substituting a bond.
Why?
Lordship, in this appeal, we have make the application that the vehicle was not involved in the accident. It was implanted later by the claimant. That's initially the case was filed again what, 302.
Milord, after letter regarding bond, it's in even no objection, Milord, regarding bond. Yes.
Okay. Heard Mr. Decker, learned counsel for the applicant, and Mr.
A. Acharya.
A.
Acharya. I'm appearing on behalf of
learned counsel for the appellant.
appellant.
Appellant of
Insurance company.
opposite party struck appellant. This interlocutory application is preferred by the applicant for allowing them to withdraw 50% of the awarded amount of rupees 82,90,605 rupees. That is rupees 41,000, no, 41 lakhs, 45,302. In MSC case number 1417 of 2018. Being deposited before the registry of this court pursuant to order dated 9/4/2025 in IS Bill number 3102 of 2024. Mr. Decker, learned counsel for the applicant, submits that 50% of the awarded amount, that is rupees 41,45,302, has already been deposited by the appellant herein before the registry of this court, and the applicant may be permitted to withdraw the aforesaid amount from the registry of this court. Mr. Asazi, learned counsel for the opposite party, struck appellant, submits that he has no objection, provided the applicant executed a bond. Further, taking note of the submission of learned counsel for both the parties, this interlocutory application instance allowed. The applicants are allowed to withdraw 50% of the awarded amount deposited before the registry of this court, subject to execution of bond of equivalent.
Deeply obliged.
Pending item 18 and 19.
As per my information, my lord, Treasury officer was on leave, my lord. So he joined, my lord, and within today, my lord. So
Today he joined.
yes. Tomorrow or Thursday, tomorrow or day after tomorrow.
Then Monday.
My lord, tomorrow or day after tomorrow, maybe his salary may be credited to his account.
On Monday we will list this matter.
Yes.
Heard Mr. R. Islam, learned counsel for the petitioner, and Mr. U. Sharma, learned counsel for the respondent, condemned. Mr. Sharma, on instruction, submits that by today or tomorrow, the current salary of the petitioner will be credited in his account. And he pressed for listing the matter on Monday.
Not today, tomorrow or day after tomorrow.
Within this week.
Yes, yes.
Within this week. And he pressed for listing the matter on Monday. Accordingly, it is provided that it's list the matter on Monday. And in the meantime, Mr. Sharma shall also obtain instruction in respect of the area salary.
Area salary, my lord. Inspector of school has sent it for counter signature of non-royal. So, my lord, after getting the non-royal from the Treasury officers, then it will send to the DSC, my lord.
Yeah, that's all right. You obtained the latest status on Monday.
Yes.
Pending 25.
Item 19, Lordship, is separate matter. 19. 19.
Put a take matter.
Take matter, but it is for admission, Lordship.
sorry, a writ petition, Lordship.
Okay.
Lordship, in this case, Lordship, on last occasion on 9/6, Lordship, 9/6, Lordship, the Finance Department informed that they have sent back the file to the Education Department with some queries, Lordship. Lordship, may kindly peruse the communication dated 27 May 2025, Lordship. Lordship, in this case, Lordship, here serial number 4, Lordship, query number 4, Lordship. From when the post is to be created to accommodate Sri Abdul Ghafoor as tutor, Lordship. Lordship, in similarly situated case, Lordship, item number 18, Lordship, and we have also annexed the order, Lordship. Lordship, may kindly peruse the order dated 3/5/2024, Lordship. Both the petitioner are similarly situated, Lordship, except their personal particulars are different, Lordship. Both's name were committed mistake by the Director of Secondary Education, Lordship, and subsequently both of them filed the writ petition on same point of time. Writ petition disposed, Lordship. The Lordship, may kindly have a look at page 34 for a moment. Lordship, the Directorate sought for clarification, authentic report from the Inspector of School, and the Inspector of School by 34 communication 9/9/2021, where Omar Ali and Abdul Ghafoor, it has been processed together, Lordship, all along. Now, Lordship, and all along, Lordship, these two petitioners' creation of post and all these things have been processed together. After your Lordship order directing personal appearance of the director, if the order is not complied in item number 18, Lordship, then the second case is segregated.
In this matter, my lord, Director of Secondary Education Assam has submitted a required clarification by letter number so and so regarding the creation of the said post of tutor. And my lord, now the file has been moved to the Finance Department for their concurrence, my lord. This is my instruction I have already submitted.
Now, there is a Lordship, in view of serial number 4, Lordship, from when, Lordship, instruction may be direction may be given to the Education Department, Lordship, because both the petitioners are exactly similar situated. And in fact, Lordship, I am holding the writ petition of Omar Ali also. And if your Lordship compares both the writ petition, except their date of appointment, date of joining, and subject are different, and rest of the things are similar.
My lord, in this matter, finance has made some queries, and regarding that, after a required clarification made by this letter, I again send it to the Finance Department for their concurrence.
Date of effect should be 1/1/2021, Lordship, because it is the mistake committed by the Secondary Education Department, Lordship.
They have already started the process for creation of a post of tutor.
Lordship.
Now it is pending before the Finance Department.
Lordship. But the query is that from when the post is to be created. Now, if the post is not created from 1/1/2021, I will be deprived of Lordship.
First, let them create it.
Yes.
We will see.
In fact, may I?
Mr. Soma, you take note of the fact that both the petitioners are similarly situated. So the present petitioner is also entitled to the benefit similar to other petitioner.
My lord, it is a writ petition, my lord, and it is the contempt petition. Already order has already been passed, my lord.
No, maybe.
So yes, my lord. It is still process is going on, my lord. So it will definitely come.
No, but you advise them that both the petitioners are similarly situated.
Yes.
So they will be entitled to benefit from the same date.
Lordship, may I submit one thing, Lordship? In respect of item number 18, Lordship, the government in the education department also issued a direction to the director of secondary education. Lordship, may I read? Therefore, you are requested to submit actual calculation of financial implication and action taken report against the officials who were responsible for committing mistake in the name spelling within a week. Lordship, it is, this is the order. It's a clear case, Lordship. The district scrutiny committee rightly wrote my name, but the state level scrutiny committee committed mistake.
You see, the matter is being processed.
Lordship, yes.
Even if we issue direction,
Lordship,
then they will take the same time.
Lordship, as your Lordship.
Already required clarification has already been submitted, my lord, to the finance
And
department.
it will be interesting to see that with regard to serial number 4, what they have done, Lordship.
Heard Mr. R. Islam, learned counsel for the petition, and Mr. Duke Sharma, learned standing counsel for the respondent, secretary. Person to order dated 9/6/2025, Mr. Sharma has obtained necessary instruction and apprised this court that the matter is now being moved to the finance department for obtaining concurrence by file number 647179. Mr. Solia is available here.
Yes, dear my lord. I have seen some while ago, my lord. He may be court, another court.
You furnish a copy to him to obtain instruction.
Yes.
Whether finance is a party here.
Finance is not party, but your Lordship has directed them to obtain instruction.
Okay. A copy of the instruction received by Mr. Sharma dated 17/6/2025 shall be furnished to Mr. A. Soliha, current standing counsel for the finance department, so as to obtain necessary instruction in respect of the file number 647179. Then rest shall list the matter. Where?
Monday, Lordship.
23rd.
23rd.
No, let this matter be segregated from the Adjournment.
Yes.
Lordship, let it be together, Lordship.
One is contempt matter, another is writ petition, my lord.
Lordship, let it be together. Otherwise, Lordship.
Why?
Because Lordship,
No, both are different matter.
different matter, but
Petitioners are also different.
Lordship.
Then-
Only thing is that I am praying for similar benefit.
No,
That of 18, item number 18.
So on Monday, he may not be able to
Then
obtain instruction in respect of this
26,
matter.
Lordship.
Let's just list the matter. Mr. Sharma, before vacation, you apprise this court.
Yes, yes.
26. On 26.
26, my lord.
There's a writ petition.
27, my lord.
Segregated from the contempt petition number.
So 532, Lordship.
Take for
Both are part hard matter. Let it be remain together, Lordship.
when these matters were taken.
Lordship, on my prayer, Lordship.
When? So this matter, this repetition may take some time.
Yes.
Lordship,
Occasion of the-
both the matter come on 26th, Lordship. In the meantime,
My lord, 27, my lord.
27.
27
Yes,
is the last
26
day.
I have.
26. Let it be 26, Lordship.
No, 20.
27. Okay, 27.
20.
The segregation matter.
It will both the matter remain
Yes.
part hard, Lordship.
Part.
MB 25.
I फाइल क्वेश्चन अपना
May I please your lordship?
ये आगे कोई करनी निकल कोई भी ना
My lord, today the matter has been listed to consider the petition we have filed for impleadment, my lord. On the last occasion, the matter was listed before your lordship on 23rd April 2025. Your lordship observed that driver owner, they are also necessary parties, so they should also be implemented. In this case, my lord, actually, award was in favor of us. MSCT passed the award in our favor. We are for the claimant. Insurance company has filed this appeal. After getting notice, my lord, we have filed cross objection. But the cross objection was time barred. So we filed condemnation petition also under section 5 of the Limitation Act. Thereafter, my lord, the matter was listed on 23rd April 2025. Your lordship observed that driver owner have not been implemented in the cross objection. They are also necessary party, they should be implemented. Accordingly, my lord, we have filed the petition
Heard
for
Mr.
implementation.
Jamullah, learned counsel for the applicant, and Mr.
Arsipal.
Arsipal, learned counsel for the
my lord a my lord there
opposing
is a
party,
my lord
struck appellant.
there is a two vehicles but both the vehicles are the same insurer United Insurance Company. The offending vehicle and the TP vehicle also.
No, first let them implement the
Yes,
driver
please,
and
yes,
owner.
fine.
We will hear you on
Right.
the appeal. This interlocutory application under Order 1, Rule 10, Certificate 2 of the Code of Civil Procedures prepared by the taken for implement of necessary party. Mr. Mullah, learned counsel for the applicant, submits that in cross objection filing number 499 of 2024 in MSC appeal number 434 of 2019. The applicant herein has not impeded the driver and owner. What are their names?
Name.
My lord.
What are the name of the driver and owner?
My lord, name of the driver owner, your lordship will find in the memo of appeal, your lordship will find. In the memo of appeal, they have filed. It is serial number of respondent serial number 4. Habibur Rahman, he is the owner. And Nur Muhammad, he is the driver.
In this application, where you have named them?
My lord, in the prayer, your lordship will find we have given the respondent number 4, 5, and 6. Respondent 4, 5, and 6 of the appeal memo. My lord. So we have referred respondent number 4, 5, and 6.
Namely, Mohammad Habibur Rahman,
Yes.
which indicate respondent number 4, and Mohammad Nur Muhammad, respondent number 5. In the memo of appeal were not implemented in the cross objection. And they are necessary party in the aforementioned cross objection, and as such, their impleadment is necessary for proper adjudication of the dispute. Mr. Pal submits that he has no objection.
My lord 4, 5, and 6. There is a two vehicle. So one vehicle, the driver will die.
No, this application is for impleadment of
It
4
is
and 5.
mentioned in his today he has furnished me the copy. I go through in file number 6. Page number 4.
Habibur Rahman
4, 5,
and Nur Muhammad.
that is the one vehicle. Owner and driver. But then that owner and driver is the offending vehicle. It has made the party meet United Insurance Company. Then another is
there any paper respondent number 6, Mr. Mullah?
Yes.
My lord,
Six is also there.
yes, my lord, I'm submitting, my lord. There are two vehicles involved.
No. Are you praying in this application for impleadment of the respondent number 6?
Yes,
Yes.
yes.
Okay. That's it.
But 4, 5 and
Don't
6,
don't
four, my lord, 4, 5 and 6, the respondent number 4, 5 and 6 of the appeal memo should be implemented as respondent in the cross objection.
But you have submitted only in respect of 4 and 5.
Lordship, sorry, my lord, subject to correction, perhaps I.
Okay.
4, 5 and 6 of the appeal memo.
The driver and owner of the vehicle, respondent number 4, 5 and 6 shall be implemented
1, 2, 3.
party in the cross objection in MSC appeal number 434 of 2019. In terms of above is I stands closed. The learned counsel for the applicant shall file amended cross objection filing number 499 of 2024 within a period of 1 week from today.
My lord.
27, or 28.
My lord, this is a limitation application. MSc appeal has been filed. There is a delay of 35 days.
Delay of
35 days.
35 days. But means a case I have learned counsel for the this application under section 5 of the limitation act is prepared for condemnation of delay of 35 days. In preparing MSc appeal, connected MSc appeal against the judgment and award dated 23rd 12th 2024 past MSc case number 884 of 2013. First by the learned member, motor accident claim tribunal shall issue notice to the respondent returnable and for step taken by Mr. Booth with AD and also the usual process within a week from today. That's the matter of fact. For
29,
Similar, same one.
okay, similar.
30.
Great.
May I appeal the lordship? We have filed one IA under order 41 rule 5. What has happened? One money execution, lordship may kindly come to annexation number 3, lordship. One money execution has been filed against us and we have filed an RFA before this honorable court, which is pending. Now, in that RFA, lordship, there is no stay order. Page 41, lordship may kindly take up for a moment of time, lordship. Hence, in absence of any stay, the lordship has kindly find it, lordship. Annexation number 3, lordship.
What is the amount?
Amount is 25 lakhs.
25 lakhs.
Now, interestingly, lordship, what has happened here? There was no business transaction between the plaintiff and the defendant.
We'll see it later on.
Lordship.
You deposit 50% of the amount for stay.
Lordship. 50% of the amount will be, lordship.
Decretal amount.
I understand, lordship. 50% of the decretal amount, 25 lakhs, it will be 12 lakhs, 50,000.
Okay. Pardon, sir, what I said, learned counsel for the applicant. This application
This will be, lordship, little bit,
under order 41. Pardon?
this amount will be, if you
No. Money decree.
money decree.
And this application under order 41 rule 5 of the rule 5 read with section 151 of the code of civil procedure is prepared by the applicant for stay the execution case number
9 of 24
arising out of judgment and decree dated 12/1/2024 in manuscript number 3 of 2020 passed by the learned civil the senior division Hailakandi.
Hailakandi, lordship.
Mr. Portesazi, learned counsel for the applicant submits that the applicant has already prepared one RFA.
Lordship.
Regular first appeal being RFA number
46 of
46 of 24.
46 of 2024. And the same has already been admitted by this court by order dated
White order dated, Lordship will kindly see. It is 15/7/2024, Lordship.
15/7/2024.
2024, Lordship.
2024.
Page 38, Lordship.
And the record has already been called for by the court, by this court.
Yes, Lordship. Call for the LCRT.
And the record has also been received by this court. Then that in the meantime, the respondent has already instituted one title execution case being title execution case number
9/24.
9/2024.
Money execution, Lordship.
Money execution case number 9 of 2024. You have received notice?
Yes. We are participating in that, Lordship. Tomorrow it is fixed. We have filed our objection
Then
also.
the applicant herein has already entered appearance and filed objection
Lordship.
before the learned executing court.
We have filed a petition, Lordship, not objection, Lordship.
Petition for the learned executing court. And that there is a requirement for staying the title execution case number 9 of 2024 till disposal of the RFA number.
RFA number 46 of 24.
46 of 2024. Otherwise, the matter would be rendered infructuous. Taking note of the submission of learned counsel for the applicant and also considering the facts and circumstances for further proceeding of title execution.
Money execution.
9 of 2024 stands state till disposal of the RFA number 40 of
46.
46 of 2024. Subject, however, to depositing of 50% of the decretal amount before the registry of this court within a period of 1 week from today.
1 week.
31.
Deplorable, Lordship.
May I please your lordship? I think 50 days of delay, lordship.
50 days.
50 days.
Third, Mr.
Espego.
Espego learned counsel for the applicant. This interlocutory application under section 5 of the Litigation Act is deferred by the applicant for combination of delay of 50 days in deferring connected appeal against the judgment and order dated 3/1/2025 passed by the learned commissioner. Employees compensation for PETA in EC case number 288 of 2020. Issue notice to the respondent, returnable in 4 weeks, that be taken by registered post with AD and also by usual process within a week from today. This after 4 weeks.
32.
May I, lordship. This case, 62 days of delay. I am here. I am also here.
How many days here?
62 days.
62 days.
33.
Lordship.
This lordship. This is for condemnation of delay. Notice may be
156 days.
156 days.
Okay. Third, Mr.
IL Ngamlai.
IL
Ngamlai. On
Okay.
behalf of people.
This interlocutory application under section 5 of the Limitation Act is referred by the applicant for combination of delay of 156 days in filing the connected MSC appeal against the judgment and order dated 23/9/2024, passed in MSC case number 1, within bracket injury 2022. Issue notice to the respondent, returnable in 4 weeks. Step be taken by registered post with AD and also by usual process within this after 4 weeks.
34.
This is an IE for condemnation of delay of 126 days, my lord, in the connected LA appeal. Read this is notice.
Third, Mr. is Gupta, learned counsel for the applicant. This application under Section 5 of the Limitation Act is referred to the applicant for condemnation of delay of 126 days as on 12/3/2025. In preferring appeal against the impugned judgment and order dated 12/8/2024 passed in LA reference case number 6 of 2024. Arising out of LA case number 8 of 2005. What is this?
My lord,
8 of 2005?
it is land acquisition case, my lord. The original
Why
land.
there is two number?
My lord,
Why two numbers
My
are
lord,
there?
in the connected LA land acquisition proceeding, this reference was filed. After the LA land acquisition proceeding, my lord, reference in the section 18 was filed. My lord,
Okay, okay.
it's a land acquisition proceedings for the city.
Also heard Mr. Gogoi for respondent number
5, Lord.
5. Issue notice. Returnable in 4 weeks. However, no formal notice is required to be issued to the respondent number 5 since Mr. Gogoi, learned government advocate, entered appearance and received notice. However, extra requisite copy of the petition will be furnished to him during the course of the day placed after 4 weeks.
35.
Four days delay in filing the MSc appealment.
Pardon?
4 days delay in filing the MSc appealment.
4 days.
4 days.
After 4 weeks.
36.
Delay of 94 days in filing the corresponding appeal.
Okay.
37.
May I please, Your Lordship? Also, there is delay of 303 days in filing this LA appeal. The respondent number 1 has already appealed.
Art means RTB, learned counsel for the applicant, and Mr.
P. Medhilo.
P.
P. Medhilo.
Medhi.
Yes, sir.
Learned standing counsel for respondent number.
Private
One-
respondent, Lordship.
One lot.
One.
Respondent number 1.
Yes.
Mr. Gogoi for
I for 2 lots.
respondent number 2.
Lordship, 1 week time may be given for filing.
File objection.
Yes, sir.
This interlocutory application under Section 5 of the Limitation Act is prepared by the applicant for condemnation of delay of 303 days. LA appeal against the impugned judgment and decree dated 22/1/2024 and 24/1/2024 passed by the learned district judge Kamrup M. Guwahati in land acquisition syndicate reference case number 2 of 2025, 2 of 2015. Issue notice returnable in 2 weeks. However, no formal notice is required to be issued since both the respondents are represented by the this council. However, extra requisite copy of the petition will be furnished to them during the course of the day. Mr. Mani, learned counsel for the respondent number 1 submits that he may be granted some time to file objection. There is accordingly allowed recessal is the matter on or out. After vacation.
Lordship, another prayer, Lordship. Lordship, another prayer, Lordship. Our names are not being shown there, Lordship. Only one of the caveator has been shown. Advocate.
Mr. Mani, learned counsel for the respondent number 1 submits that his name has not been reflected in the cause list.
Not mine as well, only, Your Lordship. My senior AC Sharma and one of my colleague. All of the,
Whether you have filed Ukalat Nava?
Lordship, we have filed caveat, Lordship. As
When?
per the, prior, I just forgot the date, Lordship. It is there in the record. I have seen it, Lordship.
Recessal reflect the name of Mr.
AC Sharma,
A.C. Sharma,
P. Methi, and K. Bora.
learned senior counsel, and Mr.
P. Methi, Lordship.
P. Methi, learned. counsel
Obliged.
for the respondent.
Item 47.
Wait, your lordship. The matter ought to have been come for hearing, your lordship. It has wrongly come on the orders column. The matter may be fixed for hearing.
So date may
Ready
be
for
fixed.
hearing?
It is ready for hearing, yes, your
Yes,
lordship.
the
Chair
LCR
has been received.
Yes, the LCR received.
Heard, Mr.
H. Buragadhai, lordship.
H. Buragohai, learned counsel for the appellant, and Madam
M does for private
M.
respondent.
does for private respondent number 1.
1.
None appears for the respondent number 3 and 4. So notice deemed to have been served upon them by order dated 3/6/2024 of this court.
Yes.
Is submitted at the part that the matter is ready for hearing, and as such, receipt may be directed to list the matter for hearing. Where is accordingly allowed, receipt shall list the matter for hearing when after vacation.
Lordship, date may be fixed, lordship. Otherwise, matter will not come, lordship.
29 July.
Obliged.
48.
Then 48 is another matter, lordship. Here, here service is not completed, lordship. Respondent number in respect of 6 and 7, lordship. It was last.
None appears for the appellant on call. However, Ms. M. does, learned counsel for the respondent number 1 to 5 present. List the matter after 1 week.
Lordship, last it was 21 to 2023.
Therefore, we have directed to list the matter after 1 week.
49.
Appellant remain absent. What we can do?
It pleases your lordship. Lordship, in this case for respondent number 12, we were asked to take paper publication, but on going through the status of the case, we found that someone appeared, lordship, and his name is also shown. He is appearing for 11 and 12, Mr. D.K. Nath. So, lordship, that way service is complete. Otherwise, earlier, all the other parties had appeared. We were asked to take paper publication on 12, but in the meantime, Mr. Nath has filed, I think, and LCR has not come, lordship.
Not received.
Not yet.
Or Ms. R.D. Mazumdar, learned counsel for the appellant, and Mr. Pegu for
I have for respondent number 10, lordship.
respondent number 10.
Lordship.
Mr. Agarwal, so lordship, is for respondent number 1 to 7, but he not there.
Respondent number 10. None appears for the respondent number 1 to 7.
And 9, 11, 12. Their names are shown, lordship.
And 9, 11, and 12.
12.
And direction for paper publication was in respect of
Respondent 12, lordship.
respondent number 12. Ms. Mazumdar, learned counsel for the appellant submits that. So there was a direction for effecting service upon respondent number 12 by paper publication, yet having gone through the records, he found that one counsel for the respondent number 12, namely
Mr. D.K. Nath
Mr.
for
D.K.
respondent
Nath.
11 and 12 both.
D.K. Nath entered appearance for respondent number 11 and 12.
Yes, his name
by
is also
filing his
reflected.
Ukalatnama.
Name reflected in the cause list. Sir. Name reflected in the cause list.
And his name is also reflected in the cause list. And as such, there is no requirement for paper publication. No, for effecting service upon him again by substituted mode, that is by paper publication. Ms. Mazumdar has also pointed out that though the record was called for from the learned tribunal, the same has not yet been received. Accordingly, it is provided that receipt shall issue reminder to the learned tribunal for transmitting the record without further delay, list the matter after petition.
Yes, Lord. It can be highly obliged.
Obligation.
May I please, your lordship? Lordship, in this case, there are direction for depositing 50% of the awarded amount, your lordship, in the stay application. However, there was some communication gap on our part, your lordship, in intimating the insurance company. So for which we could not have deposited the amount. I have already communicated with the insurance company, and within 2 weeks, your lordship, the amount will be deposited. Within 2 weeks, your lordship.
My lord, may peruse the order, my lord, day before yesterday, lordship has passed some order on 16.
Why 2 weeks?
Your lordship, because the check will come from the head office from Kolkata, your lordship. That is the problem.
Sir, why?
Lordship.
Kolkata is not far away from here. If a check can be posted at Calcutta, it will reach within 2 or 3 days.
Lordship, maybe we can fix the matter on 27th, your lordship.
No, not 27. Heard Mr. M. Ali, learned counsel for the applicant, and also heard Mr.
H.
Why,
Blagoy.
learned counsel for the respondent opposite party. Mr. Guhai submits that due to some inadvertent mistake, the order of this court could not be communicated to the insurance company. And now the matter has been communicated and the check will be deposited before this court within 2 weeks. However, considering the facts and circumstances on the record, Mr. The insurance company is allowed 1 week time to deposit the check before the registry of this court leaves the matter of 27. No. 25.
Lordship.
Obviously.
51.
May I please, your lordship? My lord, this petition was moved earlier also. The facts is this, my lord. The IMD judgment letter number 123. A decree was expert decree was passed, and the decree was put into execution. In the execution of the decree, some portion of the land has already been executed, and they have taken possession of the land. But we filed a petition before the executing court for stay of the execution proceeding and to hear the plaintiff petitioner in the case. My lord, dear petitioner, I am the defendant number 1, 2, and 3. Your lordship kindly turn to page page 26. That is the prayer in the plain. Prayer B.
On the other day,
Yes,
we have
my lord.
heard you.
Yes.
And there is a direction for effecting service upon the respondents.
Yes, dusty service was done, and they have refused to accept it.
What is your affidavit?
Affidavit we have filed.
In which paragraph you have mentioned it, they refuse to accept the notice?
Paragraph number 3, page
Three.
86. That accordingly, in terms of the order dated so and so, the deponent tendered a notice by the state to the respondents on 17/6/25 in presence of two witnesses, namely Amjad Ali Gaon Pradhan and Gaon Pradhan Chaudhary and Nitya Gopal Mandal.
Okay. Okay. But Mr. S. Sharma, learned Chief Counsel, assisted by Mr.
A. Ali.
A. Ali, learned for the petitioner. By order dated 13/6/2025, the learned counsel for the petitioner was directed to effect service upon the respondent by the Dismissal and to file an affidavit before this court after effecting service upon the respondent. Mr. Sharma, learned senior counsel for the respondent submits that though attempt was made to effect service upon the respondent number 1 and 2 by the Dismissal, yet they have refused to accept the same. And in paragraph number 3 of the affidavit, he has explained the same. Explained the same. Mr. Sharma further submits that this petition under Article 227 of the Constitution of India is preferred by the petitioner challenging the order dated 26/5/2025 caused by the learned civil the Junior Division Kamrup and Amingao in title execution case number 7 of 2023. By which the learned civil judge Junior Division Kamrup Amingao has dismissed the petition filed by the petitioner herein under section 47 of the CPC. And that the impugned order dated 26/5/2025 caused by the learned civil the Junior Division Amingao is why the petition was rejected? Yes.
Petition was rejected on 26/5/25.
The impugned order is at page number?
At page 72.
Illegal and arbitrary as the learned executing court for the second time issued writ of execution.
Rate of delivery of possession.
Writ of delivery of possession. Delivery of possession. As there is no provision for issuing writ of delivery of possession for second time. So if they refuse to accept notice,
My lord?
if they refuse to accept notice,
Yes.
we can finally hear the matter.
Yes.
Okay, list the matter immediately after reopening of the vacation and till then interim, till then the
Till then title execution 7/23 pending in the
order
court.
dated.
Till then, the further proceeding of title execution case number 7/23 pending in the Court of Civil Judge, Junior Division, Amirgaon, maybe state.
Till then, further proceeding. Let us do one thing. Till then, the impugn order dated 26/5/2025 shall not be given effect. We are not staying the proceeding, but we state the order.
52.
May it please your lordship. Lordship, this I we have filed for stay of the judgment, lordship. This I 1632.
Subject to 50% deposit. And I may be allowed to withdraw.
Lordship, first let us deposit, then take it.
It will
No,
delay
madam, they have to again file one application.
Well, I'm waiting since August 2022.
Lordship, they have not filed any execution. 147, Lordship.
So we have filed thereafter, they have filed now this stay.
No, this was
Hardness, the RD Mazumdar learned counsel for the applicant and Mr. Bhattacharya for respondent number.
1. Appearing on behalf of M. Dotto.
Respondent number 1 appearing on behalf of Mr.
M.
M. Dotto. But if you do not have your Ukalat number, can you appear and submit before the court on behalf of another counsel?
Yes, he has authorized me.
no.
How? Verbally?
Yes.
Is it
Yes.
permissible?
My lord, this is how my lord, normally
No,
we appear.
normally, usually forget about it.
So he has given me the brief and
No.
instructed me to
Unless
appear.
you have the brief, no, you have the Ukalat number from the party, you cannot enter appearance. Will not will not allow you to withdraw the amount. Let the authorized advocate come. But you deposit the.
Yes, Lordship, we'll deposit.
Appearing on behalf of Mr. M. Dotto, learned counsel for the respondent number 1.
Yes.
This interlocutory application is prepared by the applicant for staying operation of the judgment and award dated 8/8/2022 passed by the learned member motor accident claim tribunal Gulaghar in MSC case number 100 of 2017 till disposal of the MSC appeal. Ms. Majumdar submits that the applicant herein being appellant has preferred one MSC appeal.
94 of 2020.
MSC appeal number 94 of
24.
2022.
24.
24. And the same is already been admitted by this court. And also, record has been called for and received. Record received.
Received.
And that there is a requirement for staying the impugn judgment and award till disposal of the MSC appeal. Where is accordingly allowed. However, subject to depositing 50% of the awarded amount before the receipt court. In terms of this IS, that's closed.
Deposit within Lordship? Within what time?
Within 2 weeks.
Lordship, 4 weeks. Vacations are coming, Lordship. Because we have only 1 week and then there is 2 weeks vacation, Lordship. 3 weeks, Lordship.
No, office will remain open. Office of the registry will remain open. Okay, 3 weeks.
Highly obliged, Lordship.
For hearing 38.
Yes, right.
The matter, my lord, the second name is against a order passed
See,
in money appeal.
Mr. Kadir,
Yes, my
it is already 4:30.
yes, my lord, only 15 minutes left.
After reopening,
Obliged.
as agreed by learned advocates of both sides, raise the matter on 31st. 24th July.
22nd, my lord.
22nd.
Other matter on 20. Obliged.
Attendance for stay 39.
Lordship, the service report is awaited. Service report is awaited.
Service
Service report. Lordship.
completed.
Not completed, Lordship. Is awaited.
Service awaited. Art Miss,
Bid us.
learned counsel for the petitioner. Office note dated 23rd 5 2025 indicates that notice issued to the respondent return with a report insufficient address, within bracket insufficient address, RTS. Accordingly, it is provided that the learned counsel for the petitioner shall obtain necessary instruction in respect of the address of the respondent and thereafter take passage date within a period of 1 week from today by registered post with AD and also by usual process. This after 4 weeks.
Masterpiece.
Second 40.
Interim order passed earlier shall continue.
40.
Yes, my lord. My lord, I am order petitioner. The interim order was continued till today. On last occasion, the other side submitted to submit objection, but they have not yet submitted. We have not decided.
I have not. Lordship, we have not submitted. We'll go through the record, Your Lordship. We have not submitted the objection, Your Lordship.
Why?
Lordship, we will go through the record.
Art. Dr. P.C. Mazumdar, learned counsel for the petitioner, and also Hart Nisar.
A. Thakuria.
A. Thakuria, learned counsel for the social respondent. Mr. Thakuria submits that he may be granted some more time to file objection. There is accordingly allowed. Raise the matter after vacation. Till then, interim order passed earlier shall continue.
Lordship, a date may be given, Your Lord.
24th July.
Lordship.
Pardon.
Highly obliged.
My lord, that matter regarding that after completion of, my lord, the cross-examination of PW1, my lord, that the original deed is sought to be proved with original, my lord. The earlier photocopy was whether that was permissible. In that regard, my lord, that there were 3 petitions, my lord, on that that's why we were confused on that date. Why 3 petition has been passed, my lord. First petition was filed, my lord. Thereafter, that court was, my lord, presiding officer was on leave. That's why that not taken. Second day, my lord, the same petition is filed. That was allowed. Prayer is allowed, but it is not proved in origin. That the third next date, my lord, again petition filed, my lord. That on that day, it is proved in origin, put up with the record in CR. And thereafter, the defendant filed objection. And that on the basis of defendant's application, that impugn order has been passed. Impugn order that rejected, my lord, and, my lord, allowed the cross-examination 2 and 3, my lord. That was the nutshell. Whether, my lord, that can be done, my lord, whether in this petition, a 3 petition, whether there is any whisper, why they have not earlier, whether there is sufficient cause. That was not. If there is no sufficient cause, my lord, that court may allow, may not allow.
No, but the fact remains that the learned trial court has allowed.
Learned trial court once allowed and thereafter, my lord, that was modified and rejected.
Whether
Yes,
court
please.
can review the order?
Unless the review petition is filed, my lord,
Court cannot review.
I also think so. But
But that was
court
not a
and the
review
same court whether can review its own order. My lord, on its
No,
application,
no,
on its
that-
application on.
Provision of review is there in the
My lord,
CPC.
by review application is neither filed. However, my lord, court by its, my lord, on application or by its own, whether it's came to the apparent, my lord, it can be reviewed. Because there was a mistake, court on mistake, my lord, it is allowed. Court has stated, if we go through the, my lord, impugn order, at last page, my lord.
Okay, Mr. Goswami, will hear you,
Here, my lord.
but not today.
Yes,
Not
my lord.
today. As agreed upon by learned advocates of both the parties, recession lists the matter as parted immediately after reopening of the vacation. Till then, interim order pass earlier shall be.
It was already continued. Published.